What do you want? No, what do you want? We post it tomorrow, what? B group. If it's possible, I'll correct in the chamber only. B group ಕೊಡಿ ಎಷ್ಟಾಗುತ್ತೋ ಅಷ್ಟು ತಗೊಳ್ತೀನಿ. I can't give you a specific date. The reason is I am asking them to post not more than 50 matters. I can post a lot more matters, but it won't reach. So if you give the memo, they'll fix a date according to the date will be fixed depending on the vacancy. If there are already 70 matters fixed on that particular date, then there's no point in ಹಾಕ್ಸ್ಕೊಳ್ತೀನಿ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಆಮೇಲೆ ಏನು ರೀಚ್ ಆಗಲ್ಲ ನಿಮ್ಮ ಇಷ್ಟ. ಅವ್ರು ಕೊಡಿ, they'll try to manage on one particular date. Then serve a copy on somebody and get them. Ask somebody to be here. No, ask somebody to be here. After vacation.
Your Lordship, may I mention one matter?
Yes.
My Lord, last Monday, Your Lordship has ordered to list the matter, but today it couldn't be listed.
Please come tomorrow. I'll ask them what has happened.
Your Lordship.
You are for? Please inform the other side. List. List. It is orders. Please wait. Orders you can't move. Please wait. Playlist. Where is the plaint? Where is the plaint? Plaint. What is the suit for? Where is it in plaint? Where is it in the plaint? Does he admit the execution that was in the execution proceedings? Where does he admit in the plaint?
Considering the fact that they have matter, they were drafting of. And they consider the all their material aspects, when they find this sort of then. Now rely on the. And then all the material aspects has to be.
I cannot reject the plaint on suppression of facts. I have to reject the plaint if there's no cause of action from the averments in the plaint. I can't look at the defense. You're asking me to look at your defense.
So far. Material aspect, which they have stated in the judicial.
I can't reject the plaint on that ground. I'll be amending order 7 rule 11.
Material aspect they have conceived.
I know, but I cannot reject the plaint on that ground. That is not a ground enumerated in order 7 rule 11. Could on the ground of suppression of facts, if I can dismiss, reject a plaint, could it? Yes, which paragraph? Yes. Yes. This is on the ground of limitation. This is not, then I cannot. Then this is like dismissing a writ petition. I can't reject a plaint on that ground. You will succeed in the suit is all that I can say.
And they already had
When
stated.
the trial court has rejected the application of the defendant requesting the court to reject the plaint, as against which, the present revision is filed. The respondents instituted a suit seeking for an injunction, contending that they were in possession. The petitioner filed an application seeking for rejecting the plaint on the ground that in an execution proceeding, the petitioner had filed an application obstructing the execution of the decree, and in the said proceedings, the respondents had admitted possession of the petitioner, and therefore there was no cause of action. The trial court, by the impugned order, has rejected the said application on the ground that the defense of the respondents cannot be looked into, and an allegation that material facts were not disclosed would not be a ground to reject the plaint under order 7 rule 11. So in my view, the said reasoning of the trial court cannot be found fault with, since suppression of a material fact is not one of the grounds enumerated under order 7 rule 11 to reject a plaint. I find no reason to entertain the revision. Revision is therefore dismissed.
On the ground that suit lacks cause of action. Because under the plaint itself, the plaintiff have clearly
No.
admitted
How was your appeal maintainable? The trial court had allowed the application.
trial about the application. So it got dismissed. So the first appellate court rejected my application in the first argument. So the suit, the matter has been remanded back to the trial court for further consideration.
No, then how can a revision be maintainable?
The suit is still
No, the order passed is, what is the order that you have impugned? An order passed in an appeal. The appeal is now disposed of. Then how can you file a revision? You have to file an RSA if you are agreed by this.
same. But they also the suit is still
If it is an order of remand, then you may have to prefer a miscellaneous second appeal. You cannot file a revision. If you want to examine it, I don't think you can file a revision. If the appeal has been disposed of on merits, a second appeal. If it's an order of remand, then a miscellaneous second appeal.
can be necessary.
Since the impugned order is an order of remand passed in regular appeal, a revision would obviously not be maintainable. So Learned Counsel for the petitioner seeks permission to convert this revision into a miscellaneous second appeal. The permission sought for is granted. The revision shall stand converted into a miscellaneous second appeal. So the petition counsel to file an appropriate appeal memorandum in a period of 1 week. For statistical purposes, this CRP stands disposed of. Granted you a week's time to file an amended appeal. 2 weeks. Court fee ಕೊಟ್ಟಿಲ್ಲ. Court fee. ಕಟ್ಬಿಡಿ first. 200 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕು. That is the only objection that I'll take seriously. Where is the 28-3 order? What is the acquisition for? The end is. ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ? ನಮ್ಮ ಮನೆ ದೇವಸ್ಥಾನ ಕಲ್ಯಾಣ ಮಂಟಪಗಳು ಇತರೆಗಳು ಇದ್ದು. No, it is ಏನ್ ನೋಡಿದಿರಾ? ಏನ್ ತಕ್ಷಣ ಮಾಡ್ತೀರಾ ಅವ್ರಿಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀರಾ? AGA takes notice for respondents. First respondent, Shri C. Ramakrishna accepts notice for R2 and seeks for 2 weeks time to file his objections. Released on. ಅವ್ರು ಹೇಳ್ತಿದ್ರೆ ಏನ್ ಮಾಡಲ್ಲ ಅಂತ. I'll have it next week. ಅವ್ರ ಮೇಲೆ ಯಾಕೆ ಜಗಳಕ್ಕೆ ಹೋಗ್ತೀನಿ? Next week, next Monday. ಹಂಗಾರೆ ಅವ್ರಿಗೆ ಇಂಟ್ರಿ ಮಾಡಕ್ ಕೊಡಿ. One of you can talk, I can. It's a 2024 acquisition. Nothing will happen in a week. I'll have it on Monday, next Monday. Let us see what he will do. If he's not able to secure instruction by Monday, then let us see. Monday, next Monday. Court fee. ಅದಕ್ಕೆ the office objection regarding payment of court fee is overruled, since the petitioners are the wife and children of the original landowner. Issue notice. Shri Ashok Naik accepts notice for R1, R2. BMR Krishna. Shri Harish accepts notice for R3. Issue notice to R4. List of events ಹೇಳಿಲ್ಲ. ಯಾವಾಗ ಅಕ್ವಿಸಿಷನ್ ಆಗಿರೋದು? Objections ಹಾಕಿದಾರೆ ನೀವು ಅಲ್ಲಿ? Then you will refer it to the civil court. No. You are asking for compensation for what? So if you have raised a dispute, will you not refer it to the civil court? Yeah. No, that is a proceeding which is yet to be adjudicated. Who appears for the fifth respondent before the deputy commissioner? ಯಾರು ಲಾಯರ್ ಯಾರು ಅವ್ರಿಗೆ? ಅವ್ರು ನೋಟಿಸ್ ಹೇಳ್ತೀರಾ? Shri. No, without hearing the BD, how can I pass an order if they've already dispersed? You're saying acquisition of the year 2010. I don't know when the award is passed. I don't know what has happened. No, I accept there's a dispute, but I don't know the position with the BD as of now. Page. Yes.
They are the legal before this in the petition and before the assistant commissioner. The file case before that to discuss the allotment of the 60-40 ratio size and all benefits.
What is your claim to this land?
My claim is 50% out of the there is 5%. We have claiming matter to register the I am a holder of 1980. For his subsequent case, was left out in all of the 50 and 9 of the RPC.
Who appears for this Timaya or this Timaya ಮತ್ತು ರಾಮಕೃಷ್ಣ ಅವರಿಗೆ ಯಾರು? No, who's the counsel? Shri Unikrishna M is directed to take notice for respondents 1 to 4. Issue notice to R5 and R6. Counsel is also permitted to take out on the counsel who represented them before the deputy commissioners. Released on. Until then, the respondent BDA shall not disburse compensation or allot sites pursuant to annexure. Annexure L. Now consider the representative, then do whatever you want to do. ನಿಮ್ಮ ಪ್ರೇಯರೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. Next year. ನೀವೇನ್ ಹೇಳಿದ್ದು you will consider. No, I don't understand as to how I can quash the general award. If you're agreed by the general award, on what ground can I set aside the award? They don't have, it's up to them to either agree for a. If both of you agree, they'll abide by the consent award. If there's no compulsion on them to give you a consent award.
First petitioner is the wife and second petitioner is the son of the original copy.
ನಿಮ್ಮ ಹೆಸರು ಇರ್ಲಿಲ್ಲ ಅದರಲ್ಲಿ.
ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನೋಟಿಫಿಕೇಶನ್ ರಾಂಗ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ ಚಿಕ್ಕಪ್ಪ ನಮ್ಮ ಅಪ್ಪ ಇಬ್ಬರು ಸೇರಿಸಿ ಒಂದೇ ಹೆಸರು ಮಾಡಿ ಮೆನ್ಷನ್ ಮಾಡಿ. ಯಾರು ಕಾದಿದ್ದಾರೆ? ಯಾರು ಹಾಕ್ಬಿಟ್ಟು ಇದೀನಿ ಹಾಕ್ಬಿಟ್ಟು
ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆಯಾ?
ಡಿಸ್ಪ್ಯೂಟ್ ಏನಿಲ್ಲ.
ಅಲ್ಲ. Is there any rival claimants?
ಅದು ಎಲ್ಲ ಮತ್ತೆ ಆಗಿದೆ ಮಕ್ಕಳಿಗಾಗಿದೆ ಅವತ್ತು ತಂದೆ ಸತ್ತ ಮೇಲೆ ವೈಫ್ ಆಗಿದೆ.
No, see, suppose I quash the award. What is the next step?
You are supposed to give me a road sector. And after take a class and consider award. That is what.
ನಾವಾಗ ರಿವೈವ್ ಮಾಡ್ದಂಗೆ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಅಲ್ವಾ? Now, why can't you get instructions and find out whether alternative land is available Then I'll record your statement and then dispose it off. ನೀವು ಇದೇ ಆಲ್ಟರ್ನೇಟಿವ್ ಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ ಅಂದ್ರೆ then it will survive. If you are saying there no alternative land available, ಅದಕ್ಕೆ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ಟಿಲ್ಲ. ನೀವು ಹೇಳಿ 29 ಕಡೆ ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಪ್ಯಾಕೇಜ್ ಆಫರ್ ಅವ್ರು ಒಪ್ಕೊಂಡು you are agreeable for 29 to award. Now, suppose alternate land is not available. Can you find out? Relist. Council for BDA to find out whether any alternative developed land is available for compensating the petitioners instead of the amounts determined by way of a general award. Relist on. ನೀವು ಹೇಳಿ ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕಾದ್ರೆ ವೆಕೇಶನ್. Have you seen the papers?
I have not been given a copy, my lords. If it was made available, I would
Survey
have-
copy first. Relist on. Date code.
much of the experience.
I have filed an application to prosecute the revision. But from the plaintiff has not taken any steps against the, this is the defendant number one.
Who's defendant number one?
Defendant number one, but the. Land is already acquired. Where injunctions cannot be.
You're prosecuting on behalf of Kadapa.
Yes. I have filed an application for page number 62.
A defendant one is the agreement one. That is lands are already acquired.
This is not maintaining. Page number 62.
Allow the application, non-filing of necessary application then ಬಂದ್ ಮತ್ತೆ.
Now happy with that. Plaintiff should have filed an application in the suit.
Since an application seeking for permission to prosecute the revision has been filed by the LRs of the first defendant themselves, it will not be necessary to file an application as noted by the office. In what is the matter about?
But suit is for bearing filed by the other point plaintiff or on the ground that he had an agreement of sale and not claim that he is in possession. But as a matter of fact, the property has already been acquired by the KIDB, not second defendant. But KIDB has also filed a statement contending that suit is not made. I have filed an application under order 7/11 saying that the suit is not made. The other trial court was rejected the application on the ground that without considering that legal issue. As a matter of fact,
That is-
so the plain itself not disposal, that the land is acquired.
Where? Where?
Paragraph 8, the plain page number 21.
Issue notice. Who appears for Rajshekar?
I have also served.
There are other connected matters, my lord. Today itself they are listed. May pass or not?
23, 34, 35, 33.
May pass or?
I'll pass it over.
Pass
I'll
over.
take it. home. You make them a party, then I'll see, I'll dispense with notice to them. Make them as parties, I'll dispense notice to them. Weeks time is granted to the net. Next week. We just. Where is he? You pass it over.
There's some more time to file affidavit.
As a last chance, a week's time is granted to comply with the order dated 1/4/2024. Relist on.
Started at 20. 20.
Who's R6 to R8? Who's R6 to R8? ಏನಾಗಿತ್ತು ನೋಟಿಸ್ ಏನಾಗಿದೆ ನೋಟಿಸ್ ಯಾಕೆ ಸರ್ವ್ ಆಗ್ಲಿಲ್ಲ
and the 4 acres of land not a field and part belongs to me, but the award of the part of 1 acre project that is the empty folder from 1962 which all these birds they did not to register document.
ಅಡ್ರೆಸ್ ಲೆಫ್ಟ್ ಅಂತ ಬಂದಿದೆ ಅಡ್ರೆಸ್ ಲೆಫ್ಟ್ ಅಂತ ಬಂದಿದೆ ಪೋಸ್ಟಲ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್
But the allotment is folder, but they were not being solved. Then 6 crore is the company.
is the owner of an hospital and is not served
The owner of the hospital not being solved.
And someone stole.
Also then there is that the brother-in-law account of 6 years being served.
what are you challenging here
So that was the award. My band is that for it. As the thing, say.
you had filed a petition under section 18 that is rejected ನೀವು ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಕಾಂಪನ್ಸೇಷನ್ ಅವ್ರಿಗೆ
In this matter, I have filed wakalat for R6 my lordship.
or R6
R6.
what about R7
77.
he said is a brother alva
R6 I have filed. It is not put up. My name is not shown.
then R8 what about R8
R8.
Yaar R8.
One.
R4 ka R6 ki antar hai.
No, my lordship. I have only filed for R6 my lordship. Vipin Hegde.
R7 not entered into an agreement with
R4 is deputy director of land records country
Sorry, sir. R6 my lordship. It's a mistake.
Vipin
I'm so
Hegde states that he has entered appearance
R4 is
on behalf of R6
DDLR Miller. R4.
office to print his name. You're sure you're not going to take notice for R7, brother-in-law?
No, my lordship. R6 only my lordship.
Who's R8? Why have we made him a party?
But the R7 Millard, my land, Millard, without my knowledge, they entered an agreement with RA. Sold my property in their name, but the acquisition is for 4 acres of land, they have been acquired. 2 acres, 12 guntas, they pass an award. Remaining land, my lord, I doesn't have the land. Therefore, my lord, the award has not been passed on the ground that my lord, my land, my lord, somewhere it has been demarcated. All these things happen to be at the instance of options to RA. Now ultimately, they sold in favor of the RA. Somewhere.
Then I'll place them ex parte, that's all, R7 and R8,
No.
since
I will
paper
take it.
publication is carried out in respect of R8 and there's no representation. So notice to R8 is held as sufficient. R7 ಗೆ ಅವರೇನೋ ಸರ್ವ್ ಆಗಿದೆ. R7 ಸರ್ವ್ ಆಗಿದೆಯಾ?
Last time, yeah.
ಇಲ್ಲ, BR ಮಧುಸೂದನ್ ಅಂತ ಇದೆ.
Paper publication ಮಾಡಿದ್ದಾರೆ.
Kindly show BP negative.
R7 ಅಂತ ಇದೆ. Costed R7 BR Madhusudan served. First list ಅಲ್ಲಿ.
Last title ತೋರ್ಸು. ಆ list.
Lordship, I require 2 weeks time in this.
He is nothing to say, that's what I am saying. 4 acres of.
Why do you make him a party? You make him a party, then he has a right to file objections.
ಆಯ್ತು.
My lord, in this case, state has been directed some directions. Partly has complaints has been done. Is under process, my lord. Direction is that to scan all the LR records, my lord. I produced the statistics. ದೇವನಹಳ್ಳಿದು ಆಲ್ಮೋಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ, ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಸ್ವಲ್ಪ ಸ್ವಲ್ಪ ಪ್ರೋಗ್ರೆಸ್ ಅಲ್ಲಿ ಇದೆ.
I'll call this after 2 months, let us see.
Can be monitored after 2 months, it may be.
Already,
called
AG.
to the I'll
Please do some recorded communication.
furnish the whatever the.
The 10th of April 2024, in which it is stated the digitization process is underway. Released after 8 weeks.
Place.
Last session, plan modification of the plan was directed to be considered.
ಏನಾಯ್ತು?
We have issued them an endorsement saying that to clear certain lacunas which are in this one, that they'll have to clear all those lacunas, then we'll be able to consider.
Some of them are actually incorrect, my lord, we'll clarify. Some of them we need to change the shape of the park. That we are willing to comply, some time may be given. On Friday evening around 6
Complaints.
o'clock, you got the intimation.
What do you want me to do?
Call after 3 weeks, my lord. I'll comply with it. One of them is
Counsel
no
for
objection from the
BDA.
areas of concern.
Has filed a memo enclosing an endorsement dated 10th of April 2024, in which certain deficiencies have been pointed out in the application submitted for the modified plan. Land Council, the petitioner submits that the said deficiencies will be cured within a period of 2 weeks. Relist. To continue.
But interim order, what I am told is, in spite of a last order undertaking given by them that they'll not construct, still the construction on a park and the civic amenity is going, park area is going. They are putting up the construction.
In fact, in this, they have said that there is some civic amenity.
No, I had passed an interim order that you will not put up any,
Construction is not put up, my
he's saying,
they have inspected the place, my lords. After that also, they have not.
file an affidavit, I'll initiate action against them.
please.
File an affidavit with photographs, I'll initiate contempt proceedings against them.
Even in this, they have not intimated that some.
Okay, let him file an affidavit.
Please.
This case, my lord, pursuant to the last date, my lord, talks were held, but no breakthrough. The difference is quite vast, my lord, in what they are demanding and what actually prevails. But an honest and sincere effort was made between the VGNL.
We have convened the meeting of the Raita in the presence of official, wherein officials have offered to pay 48 lakh rupees per acre, as against the Raitas demanded 4 times of the amount.
ಏನ್ ಮಾಡ್ಲಿ?
It was not federalized. See, if you have given 48 lakh per acre, the same rates will be provided for adjoining villages also where the channel is going on.
Said 80 lakhs or something for the adjoining.
They have demanded. No, which is not.
Just 1 second.
Which is not.
Filed a statement where my lord, award was passed, payment was made in respect of 3 villages.
This is the dates and events for the first one.
That is altogether different. The notification is different and the award is different. And
Then I'll
circumstances.
decide the petition on merits.
Please, man,
If this petition, if the acquisition is quashed, you will suffer the consequence.
please.
Lord, in fact, I've got all the papers only on Friday, my lord. Lordship has it on next Monday, 22nd. I will argue on the main itself.
List.
Second. But interim order may kindly continue.
Remove to continue.
But
But I filed my objections, I'm sorry, my lord. I filed my wakalat on Wednesday, my lord. My name may kindly be shown in the list.
Should be Vachan. And constable of BDS submits that he has entered appearance last week. Used to print his name and relist on.
My lord, serial number 17, I am appearing for the petitioner, my lord.
He, Mr. Vachan has entered appearance, he wants time.
Please, my lord, please. Your lordship may have it next week, my lord.
22nd.
Please, my lord, please.
Obliged, my lord.
The 5% reserve on excellence man.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ affidavit copy ಕೊಟ್ಟಿದ್ದಾರೆ.
My sister is also an already serviceman. He retired from the Indian Army. He was allotted in year 2006 years by the entire settlement. Thinking about how to execute it. The suit is pending in respect of the segment of.
Now, where is the affidavit filed pursuant to this order 19-3?
No, man. Affidavit is ready, my lord. Officers are in election duty, my lord.
ಏನಂತ ಹೇಳಿದ್ರೆ affidavit ಅಲ್ಲಿ?
Affidavit is ready. Stray sites ಏನು ಎಷ್ಟು ಖಾಲಿ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಇದೆ, ರೆಡಿ ಇದೆ. ಸೊ ಸ್ವೇರ್ ಆಗಿಲ್ಲ ಸರ್.
ನೋಡಿ ನೋಡ್ತೀನಿ.
ಕಾಪಿ ಇಲ್ಲ. ಅದು ಅಪ್ರೂವಲ್ ಆಗ್ಬೇಕಾಗುತ್ತೆ.
So technically speaking, if ಇದರಲ್ಲಿ ಡೈಮೆನ್ಷನ್ಸ್ ಹಾಕಿಲ್ವಾ ನೀವು ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಡ್ ಎಷ್ಟಿದೆ ಬಾಕಿ ಅಂತ?
ಡೈಮೆನ್ಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು.
ಇಲ್ಲ ಇದಕ್ಕೆ ಹಾಕಿದ್ರ ಸ್ಟ್ರೇ ಸೈಡ್ ಹಾಕಿದ್ರ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿರೋದು. ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಡ್ಸ್ ಎಷ್ಟೆಷ್ಟಿದೆ ಅಂತ ಬರ್ದಿಲ್ಲ. ಎಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ಗೆ
ಅಲ್ಲ 30-40 ಮತ್ತೆ 40-60
ಅಲ್ಲ ಸ್ಟ್ರೇ ಸೈಟ್ಸ್ ಮೆಜರ್ಮೆಂಟ್ ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು.
ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ಸ್ ಕೇಳಿರೋದು ಅದ್ರ ಮೆಜರ್ಮೆಂಟ್ ಪ್ರಕಾರ ಕೊಟ್ಟಿಲ್ಲ.
ಅದ್ ಕೊಟ್ಟಿ.
ಅದೊಂದು ಹೇಳಿ.
ಈಗ ಇವ್ರದ್ದು ಏನಿದೆ ಅಂತ ಅಂದ್ರೆ ಸ್ಟ್ರೇ ಸೈಟ್ ಅಲ್ಲಿ ನಮ್ಗೆ
ಹೌದಲ್ಲ, ನನ್ಗೆ ಇಫ್ ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ ಸ್ಟ್ರೇ ಸೈಟ್ಸ್ ಅವೈಲಬಲ್ until you allot them to alternative site holders, I will not permit you to auction it. You are now working on in definition of the rule, which says that stray site can only be auctioned when there are thousands of people waiting for an alternative site. You'll have to first satisfy those people, and then if there's anything, you auction it under the stray site rules. So I need you to state the amount of sites available, alternative site applications, measurement wise, site wise measurement.
ಸ್ವಲ್ಪ ಎಲೆಕ್ಷನ್ ಇರೋದ್ರಿಂದ ಸ್ವಲ್ಪ ಮಾಡ್ಲಿಕ್ಕೆ ಆಫೀಸರ್ಸ್
ಇದು 1111 ಸಿಕ್ಕಿದ್ದಾರೆ ಮೆಜರ್ಮೆಂಟ್ಸ್ ಗೊತ್ತಿಲ್ಲ ಎಷ್ಟು ಏನು ಅಂತ.
ಆಕ್ಚುಲಿ 3 ದಿವಸ ಎಲ್ಲಾರ್ದು ಎಲ್ಲ ಸ್ಟಾಫ್ಸ್ 4 ಇದರಿಂದ ಡಿವಿಷನ್
ಯಾವತ್ತಿದ್ರು ಮಾಡ್ಲೇಬೇಕು ತಾನೇ ಅದು.
ಈಗ ಸ್ಟಾಫ್ಸ್ ಇಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಈಗ ಇವ್ರದ್ದು ಏನಿದೆ ಅಂತ ಅಂದ್ರೆ ಇವ್ರದ್ದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ 5% ರಿಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ನಾವು ವಿಲ್ ಕನ್ಸಿಡರ್ ದಿಸ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
I am not prepared to accept your argument that you can allot the auction the stray sites when there are thousands of applications pending for alternative sites. I would want you to dispose of those alternative site applications as against the stray sites available. You cannot make a profit out of your mistake. They have paid you money, they are waiting. For how long can they wait? Please mention the site measurements next Monday.
ಮಂಡೇ ಆಗಲ್ಲ ಪ್ಲೀಸ್, ಆಫೀಸರ್ಸ್ ಇಲ್ಲ ಸುಮ್ಮನೆ ಎಲ್ಲ ಎಲೆಕ್ಷನ್ ಡ್ಯೂಟಿಲಿ ಇದ್ದಾರೆ. ಸೊ
When it comes to the BDA states that some more time is required to file the affidavit. ಯಾವತ್ತು ಹಾಕೊಳ್ಳಿ?
26ಕ್ಕೆ ಎಲೆಕ್ಷನ್ ಇದೆ.
Is the last chance post on 4th of June for further consideration.
I have not yet received the information that apart, they have not made the BBMP as party. The relief is against BBMP. The relief
Office
is to-
objections, you know.
That prayer is also of injunctive nature, my lord.
The last chance, a week's time is granted to comply with the office objections. The office objection not complied with, petition stand dismissed for non-prosecution. Week's time.
Compensation with respect to release the third parties and so when the landlord is filing an application to release the compensation, they issued an endorsement in your 14 stating the land is not traceable. Subsequent to in 15 at page 35, they issued an endorsement stating the 771 square feet of land is traceable and they have sent some communication to the revenue department. Hence, the same was pending. Meanwhile, in 2015. My brothers and sisters have filed a writ petition. I filed a writ petition and I also filed a writ petition subsequent.
Which is the other writ petition?
So the page 35, 47131 of 2015 and page 43. So during the pendency of this petition, There was a direction to release the compensation with respect to 771 square meter.
No, no, just for Union of India, madam. I don't have the copy, madam.
Week's time is granted to comply with the office of objections. Petition is also directed to serve a copy on of the petition and its annexures on Sri Gautam Dev C. Ullat list on.
Filing the objections today for objection.
By substituting 35 copy, 35 copy also.
Objections.
No, this revision is against which order?
Eviction.
Revision is against which order?
Eviction.
Rejection of against me, and that was allowed by the trial court. I challenged it, hence this CR. In the meantime, I felt contending that I am the agreement holder of a property, not a tenant. Because tenant seizes once the agreement is coming to effect. So.
They admit the agreement of sale?
I filed application.
No, they admit the agreement of sale?
No.
Because what happened, no, my lord. The person who has executed the agreement paid, his children are executed the sale deed in his favor. Therefore, that the since sale deed is there in the tenant, I submitted the original agreement to the court. Now, specific performance, I want to establish my claim before the court regarding execution of the sale agreement. And I filed application for return. Since they are disputing, I want to send it to the fingerprint expert. For that purpose, evidence of purpose, the original sale agreements are required. I submitted.
File the objections today.
Sale.
I served the copy also.
Objection is seen required that document required for criminal case. After marking, you can take it there also, no problem.
My vendor has filed a criminal case before PCR has been filed, madam. There, this documents has been required. Because
Is an order passed in the criminal case?
No, madam.
Have you made any application in the criminal case?
I think they made.
I think correct ಆಗಿ ಹೇಳ್ರಿ.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ PCR ಹಾಕಿದ್ದಾರೆ ಬಟ್ ಅದ್ರ ಬಗ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲ ಅಂತ ಬಟ್ 468 417 420 ಇವರು ಅಗೇನ್ಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್ ಪಿಟಿಷನರ್ ಅಗೇನ್ಸ್ಟ್ ನಮ್ಮ ವೆಂಡರ್
Your only defense in the
certified they can produce the certified copy.
Original document for the criminal case. For that, my lord, I want to send it to fingerprint expert this document and after the cross examination. So originally it's
no, but until you get a sale deed, you cannot get title. What the only defense that you have is you are an agreement holder. If you succeed in the suit.
Agreement says, my lord, once the agreement is entered into, then the claim ceases.
Correct, but that is not an admitted case. They don't admit the agreement. Is it a registered agreement of sale?
Unregistered, madam.
I paid stamp duty as per.
No, you may pay stamp duty, but how can you defend this ejectment suit? If you succeed in that suit that you have filed.
That's not the case, my lord.
The Supreme Court held it. If you succeed in the suit.
No, once the agreement is entered into the party, then this one tenancy claim ceases. Here also, my lord.
No, that was the case where the agreement of sale was admitted.
Since parties no more, my lord. They are not agreed.
No, this judgment cannot be the precedent to say that whenever an agreement of sale is set up, the relationship ceases.
And in the present case, my lord, the vendor died, my lord, his children.
So until you establish the agreement of sale, until you establish title, how can you resist the suit for ejectment?
No, my lord, my submission is like this. I have created the agreement. I have to establish the agreement in the specific performance which is pending.
But if you establish that, you will get back possession.
No, my lord, the commercial premises, I have been enjoying the premise from last several years, my lord.
What can be done?
No, if your lordship gives a finding that there is no proper agreement or that.
I will not say anything. I will simply say that in the event you succeed in the suit filed by you for civic performance, you will be entitled for possession. What is the premises?
Shop, shopman, commercial.
I will dismiss the revision and reserve liberty for you to secure possession after
Let me try to
the list.
Date of 20.
ನೀವಿದ್ದೀರಾ ಅದ್ರಲ್ಲಿ 23.
22.
Passor.
There is a delay in the revision. It's a proof of specific performance.
ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳ್ತೀರಾ ನೀವು 23? Passor ಅಂದ್ರೆ ಏನ್ ರಿವ್ಯೂ? What is the mistake? Yes. Hmm.
11 employees were reabsorbed on the same day. Date of absorption for E group and G group are only. The date, my lord had a 50 in order. Lord has delayed upon the order dated. That is, parasite order dated 16/4/2005.
11 D group employees reabsorbed as C group.
You have got the effect of date on which the it has been required in G group. So C group post for the G group date is what I say. My lord have kept the table. My petition,
Which table?
page 16. Page 16. This is where my lord has relied upon of 11 employees.
ಈ ಗ್ರೂಪಿಗೆ 1,2022 ಸಿ ಗ್ರೂಪ್ ಸೇಮ್ ಡೇಟ್ ವಾಸ್ ರೆಗ್ಯುಲರೈಸ್ಡ್. The reference under which my notes the same benefits was extended to the petitioner's case.
No, so what I've said is you observe them as C group employees with effect from the date on which they are observed in the D group post.
The reliance was placed is stated.
It is the same, isn't it?
Yes, yes. My notes, page 50, para 18, the previous page. This is the petitioner's case.
So you will have now observed them with effect from 1/1/1990.
My notes, the reason for finding a review is there. My notes, because this year, 11 employees is concerned, though they were qualified earlier for reabsorption of E group post, relatedly, they were given the regularization order started from 1/7/2002. So that is the reason why the date of regularization of D group post and C group post can arise. But the answer my lord is pointed at page number para 21 page 17.
Para?
Para 21. Page 17.
Yes.
Yeah.
The review again, this was not the argument that you advanced then.
For the other reason is that the petitioner has approached the court earlier. And has approached the court. There are totally 115 similar employees. We have regularized
Sachin, you observe them in group C posts. So it should go, you observe them into group C posts because they were eligible to be appointed as group C post. How can you now give a future date? Group D post regularize agodina, our group C ke regularize madbekit ನೀವು. Because they were qualified. You made a mistake and you observed them first as group D post and thereafter subsequently as group C.
So for the petitioner's case, my lord, earlier they have approached this court with this grievance. This court has sealed the order of saying that my lords have a look at the page number 101. The effective date should be given only from 9/11/1995. 101. The same petitioner has approached this court. My lords, 101 is the final order. The starting order, my lord, the preamble portion of the order starts from page 48 is the cost where the petitioners are to this court. Batch of the petition was filed. And 101. So when all 115 employees were given effect to C group post only with effect from 9/11/1995. My lords, for clarity, my lords have a look at the page number 89. All petitioners came to this court, including 115 employees. Page 89.
Page?
89.
No, but they filed the subsequent petition because of this order that you passed. They were happy with this 9/11/1995. But since you made a distinction, when you observed 11 group of employees, 11 employees, that's why they came to the court.
No, 11 group employees, that's the reason. My lord has relied upon the 11 group employees. The 11 group employees, my lord, that is page 16 table.
Where is the order regularizing those 11?
Yes.
16/4/2012.
And my lord should find it at page number 102 onwards. 102, Ravindra, just compare my lord, my table, page 16, with the order 102. 11.
Now, where is 16/4/2012?
Yes, clearly.
Now, give me the order, it is 16/4/2012. Which page? 16/4/2012, the order that I relied upon.
Yes, my lord has relied upon.
Where is that order?
For the part of collection.
Now, give me the order, it is 16/4/2012.
Petition was part of.
ಯಾವ next year?
Page number 45. Page 55. Order dated 20/16/2012. The table my lord to find it at reference at page 54.
Page?
Table ಮಾಡಿದ್ದೀನಿ my review cut out the table page 16 para 20 to 11 members of which my lord has divided up. ಈ ಗ್ರೂಪಲ್ಲಿ ಸಿ ಗ್ರೂಪ್ ಕೆಲವುದೆಲ್ಲ ಒಂದೇ ಡೇಟ್ ಇದ್ದೇ ಇಲ್ಲ ವ್ಯತ್ಯಾಸ ಈ ಸೇಮ್ ಡೇಟ್ ಇರುವಂತದಕ್ಕೆ ಯಾಕೆ ಸೇಮ್ ಡೇಟ್ ಬಂತು ಅಂತ ಹೇಳುವ ಒಂದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕಾರಣ.
This was not argued then. You did not say that that was date of the regularization.
The restriction was filed. My lord had counted it.
Take out notice. Who appeared there? The MJ Raghupati is there to take notice for respondents. 125. AJ accepts notice for R6. Relist on. ಏನ್ ನೀವೇ ತಾನೇ ಮಾಡ್ಬೇಕು ಪ್ರೆಸ್ ಮೀಟ್ ಮಾಡೋದು? ನೀವು ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ, ಅವ್ರ ಕಂಟೆಂಪ್ಟ್ ಆಗಿರೋ ಬಂದು ಹೇಳಿ ನಂಗೆ. Ready na?
My lord, this appeal was dismissed for non-prosecution. It has now come for restoration of that appeal. But I have I have no objection in allowing the application. It can be restored.
I'll dispose it of if
But it is not this way. It is not covered. In fact, it is not covered, my lord. In fact, last occasion also. I had made a
one by
submission.
2024. The order dated 27/2/2024, dismissing the petition for default is recalled and the writ petition is restored. ಮಿಕ್ಕಿದೆ ಏನ್ ಬಂದಿರೋದು?
ಅಲ್ಲ, ಅದು second petitioner is no more. Parallel, that is, he is represented by other petitioner.
P1 is no more.
P2.
Who's dead now?
P2. Second petition.
It is stated that the first petitioner is no more. And our LRs, that is P2 to P4, are already on record. The necessary note be made in this regard in the cause date.
My lord, as far as this Mr. Venkateswamy is concerned, my lord,
The same portion of the survey number has already been quashed.
my lord, it was on a suppression of facts. The earlier writ petition was dismissed.
First ಹೇಳಿ.
ಅಲ್ಲ, ಆಗಿದೆ. In fact, he has produced that, my lord, before his honorable. Yes, it is. I concede, my lord, it has been produced. And similar survey numbers have also been produced. But as far as this petitioner is concerned, well, two issues, my lord. First thing is that he is a subsequent purchaser. Venkateswamy, subsequent, there is a partition, no doubt. But he himself is a subsequent purchaser. He bought it from the original owner. My lord, he cannot now challenge this acquisition. That apart, this Venkateswamy's family had also filed a petition challenging the very same acquisition that was suppressed. When I brought it to the notice of this honorable court, my lord, an application for amendment is filed. Then they concede, yes, by mistake, it happened, etc., etc. My lord. My lord, it is not as if, my lord, it is.
Venkateswamy filed the writ petition challenging acquisition.
Yes, my lord, yes.
And what happened to that?
That got dismissed. Not only that, the co-owner of the property, which my learned friend is.
Then how can you maintain the writ petition if your husband's petition was filed, it was dismissed?
Let them also show the sale deed of Venkateswamy, my lord, how he got it. Conveniently, my lord, he is now producing only the partition deed.
No, Venkateswamy had filed a writ petition according to him, which was dismissed. If his petition was dismissed, how can you file another writ petition?
Kindly see his application for amendment also.
Right, first. Because if Venkateswamy's petition is dismissed, I can't. First. Amendment.
My lord, my instruction, my lord, last time your lordships had passed an order. Lord. They were supposed to be present on 10th. And BDA was supposed to show them the demarcated land. Lord, now I am informed, my lord, in fact, I also spoke to the commissioner personally yesterday. In respect of 27 sites, 21 sites has been demarcated. There is no issue at all. My lord, they are, in fact, this is to bring it to your lordship's notice that the present petitioners, my lord, have purchased it from their vendors, my lord, were allotted these sites. The vendors of the petitioners, my lord, were the land losers in Arkavati. So for the land their land which we acquired, we gave them 27 sites, sale deed was executed, they were put in possession. The person the land loser who got the sale deed in their favor, he then, my lord, executed a sale deed in favor of the present petitioners, where again, it's also written that the possession has been handed over to the present petitioners. However, since there was an issue with regard to the demarcation, they filed a writ petition. There was an order by this honorable court
that demarcate it and to show it. Then, my lord, there was an endorsement which was given by the BDA, which may not be correct, that since the layout is not formed, we will give you alternate lands in Kempegowda, which, my lord, they challenged. On the last occasion, my lord, I made a submission that the same sites are available. So now, my lord, my instructions are on 10th, which your lordships had asked them to be there. They were, my lord, not present, but however, my learned friend, my lord, when I spoke to him outside, he said that that the BDA did not come, my lord. Now on that, I cannot comment. However, my lord, the instructions from the commissioner are in respect of 21 sites, which they have a sale deed. There's absolutely no problem. They can enjoy, my lord. There is nothing for us to do because they are the purchasers from the person whom we have executed a sale deed. In respect of 6 sites, my lord, there are some temporary sheds, my lord, which have come up in this, which they have put in between 2 sites. So that also there's an internal communication that, my lord, the BDA can demolish. My lord, there is a judgment of the Honorable Division Bench who protects its possession. Minimum force can be used, which we can do. But however, one small technicality which will be there is, my lord, since we have lost possession, we have already given it to them. Lord, we can assist them in giving that only with regard to that election. We have some issues in respect of the 6 sites as of now. We are also informed that some suits are filed. In those suits, my lord, they are not parties and there is no injunction. So there is no problem at all in respect of 21 sites. 6 sites, my lord, there are some sheds, which, my lord, if your lordships also, my lord, would say, my lord, that the BDA to assist or whatever, my lord, we will, after the conclusion of the election, my lord, we will demolish it and give it to them.
Who have put up the sheds?
Lord, that we don't know, my lord. What happens also, my lord, is, our thing also, my lord, is once, my lord, we sell it. Now, whether the sheds have come up after we have sold or before we have sold also is an issue. But we'll not get into the technicalities.
ನೀವು CD report ಕೊಡಲ್ವಾ before the sale deed? CD report ಮಾಡ್ಲಿಲ್ವಾ?
There was no problem, it seems, my lord, that
No, even then there should be a CD
my
report.
lord, that is the reason why I'm saying we will, my lord, in respect of those 6 sheds, my lord, we will demolish that, my lord, with or assist them or whatever your lordship says, we'll do that. 21 sites, my lord, in the same Arkavati which has been given. In fact, these were the sites which their vendors identified and said these are the sites which he wanted.
No, the fact that your endorsement says that the sites are not available.
No, not that sites are, that layout has not been, that may not be correct.
So
that
then-
your lordships will have to caution, my lord, that will have to go. But now the present position is the sale deed in respect of which sites they have the sale deed, they are available. Out of 27,
Take those
if
21
they
sites.
want, my lord, they can even go tomorrow or day after.
The present developments.
Page?
It's 75. It's 69/2021.
That's an extra F.
Next, it's 76. They themselves admit that in view of 27 sites, what is the status? There is a requisitions filed, there are suits filed, because of which, they were unable to form the site itself. But now, my lord, they're coming and saying that the sites have been demarcated. Let them say, which are those 21 sites which have been demarcated, and let them say, they any encumbrance. There is no issue, my lord. We will take it. We are bound to take it also. At one breath, my lord, they'll say that sites are not being formed. Now, my lord, they're coming before the court and saying, you have only demarcated.
No, this is subsequent to that, subsequent to this.
The page 76, read the first 3 lines immediately after the tabular column. ಮೇಲ್ಕಂಡ ಪಟ್ಟಿಯಲ್ಲಿನ ಒಟ್ಟು
27 ನಿವೇಶನಗಳನ್ನು ಸ್ಥಳದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ, my lord, I'm not.
read that complete.
Yes, ma'am.
800 ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 81/4
ಈ ಹಿಂದೆ ಬಡಾವಣೆ ರಚಿಸಲು
ಪ್ರಸ್ತಾಪಿಸಲಾಗಿ
ಕಾಯ್ದೆಕಾರಿ ಬಡಾವಣೆ
ನಕ್ಷೆಯಲ್ಲಿ ನಿವೇಶನ
ಸಂಖ್ಯೆಗಳನ್ನು
ಅಳವಡಿಸಿಕೊಂಡು 2016-17ನೇ ಸಾಲಿನಲ್ಲಿ ಅನಧಿಕೃತ ಕಟ್ಟಡಗಳನ್ನು ತೆರವುಗೊಳಿಸಿ ಜಮೀನನ್ನು ಸ್ವಾಧೀನಪಡಿಸಲಾಗಿತ್ತು. So you are admitting that there was unauthorized constructions, you demolished it and then handed over to them. ತದನಂತರ ಭೂಮಾಲೀಕರಿಗೆ ಭೂ ಪರಿಹಾರವಾಗಿ 40/60 ಅನುಪಾತದಲ್ಲಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ನಿವೇಶನಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡಲಾಗಿತ್ತು. ಹಂಚಿಕೆದಾರರಿಂದ ತಾವುಗಳು ಖರೀದಿ ಮಾಡಿರ್ತೀರಿ. ಆದರೆ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಈ ಹಿಂದೆ ಇದ್ದ ಕಂದಾಯ ನಿವೇಶನದಾರರು ಪ್ರಾಧಿಕಾರದ ಭೂ ಸ್ವಾಧೀನವನ್ನು ಪ್ರಶ್ನಿಸಿ ದಾವೆ ಹೂಡಿ ವಿವಿಧ ನ್ಯಾಯಾಲಯಗಳಿಂದ ತಡೆಯಾಜ್ಞೆ ಪಡೆದಿರುತ್ತಾರೆ. ತಡೆಯಾಜ್ಞೆ ಜಾರಿಯಲ್ಲಿರುವ ಕಾರಣ ತಮಗೆ ಹಂಚಿಕೆಯಾಗಿರುವ ನಿವೇಶನಗಳನ್ನು ಪ್ರಾಧಿಕಾರದಿಂದ ರಚಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದು.
Lord,
Namaga
that is
actually-
why upfront I brought it to your lordship's notice, my lord, that there is an endorsement. My lord, but now at present, my lord, like on the last occasion, Lord, the question of,
Now, but they cannot say, but we'll demarcate it to take the position yourself. They themselves, but there are third party rights created.
no, my lord, now the present situation, my lord, the present situation is in respect of 21 sites, my lord, it has been clearly demarcated. They
What
can, what?
Which are these writ petitions that you refer to here, court case details? WP 33196 by 2016. You're referring only to that.
Seal number 1.
No, there are WP 48750, 44246, 39427, 33196, OS 3325, OS 3326.
Lord, may I make this submission? May I make this submission? Now, my lord, last time, since we made that submission, your-
Are these
my lord,
petitions?
my lord, like the information now I have, my lord, is in respect of 21 sites.
Is there litigation or not?
No, my lord, there is no litigation.
21
There, 21 sites, there is no problem at all.
Which
This
are
is,
the-
my lord,
which are
I've
the-
got the instructions from the commissioner himself.
Which are the 21 sites?
My lord, that they can, my lord, may I just make this submission also? Now on 10th, my lord, I do not want to say that what he is saying is right or wrong, but I cannot disbelieve what our officers also have said. Now, who is right or wrong, I'll not get into that. My lord. 10th, my lord, if they had come, we would have shown them these sites, all these sites which have been demarcated, which they have already purchased from the allottees from whom we had allotted and sale deed executed. So that we say that they did not come, they say that they came, and my lord, I'll not go into that. Tomorrow or day after also, my lord, let them, we will show it to them. It has all been done now. Now, only in respect of 6 sites, this is my instruction and information. Only in respect of 6 sites, there are some sheds which we are willing to, my lord, demolish. But however, my lord, we'll seek the court's indulgence in getting such an order also.
If there is an interim order granted in some litigation,
No, my lord, there is no injunction in respect.
there is, your endorsement indicates that there is a writ petition pending.
No, my lord, as on today, that was earlier. As on today, my lord, they have, in fact, Mr. Shravan, Sachin's colleague, my lord, he has even looked into those suits. They've seen there, they are not parties. There is no interim order of injunction, nothing. So, my lord, my instructions are in respect of 21 sites, absolutely there is no problem. My lord, all that I would request your lordships is, my lord,
You're prepared to take post on
tomorrow or
21
yes,
sites?
it is demarcated. My lord, handing over possession may not arise.
We are not giving this take possession. But this is what is taken. Ideally, the site has not, they have issued possession certificate also.
No, not to you. The possession certificate is issued to your vendor.
Vendor, yes,
So there's no fresh possession certificate
Possession.
issued to you.
What has happened, but there also not, there is suppression of the Malad of.
No, are you prepared to take possession? I'll ask them to be present tomorrow here. Go along with them, take possession, put up a compound wall, do whatever you want to do.
yes,
We are.
Tomorrow.
yes,
Keep the engineer present tomorrow.
please.
Release tomorrow. The executive engineer, the executive engineer, the concerned executive engineer shall be personally present before the court. And so also the petitioners. Go from here only and get it done.
Yes, obliged.
ಸರಿ ಮಾಡಿದ್ರ ಅದೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
But now they have filed an IA for amendment.
Even without that, could be considered. I will not show only 2 documents. Only 2 documents.
No, the
What is the
matter is,
amendment you have sought for?
And not that. Still not. Disaster Management Act.
let this application be allowed. I may be permitted to file my additional statement of objections.
Only 2 suppressions have been.
No, this has to be heard means that I need some time, Lords, because I have to file my objections and then argue the matter.
Application for amendment is unopposed. Hence, the said application is allowed. Additional objections, if any, by
2 weeks
released on.
after vacation.
ನೀವೇ 2 weeks, ನೀವು ಯಾವತ್ ಬೇಕಾದ್ರೆ ಹೇಳಿ ನೀವೇ. 2 weeks means, my lords, it crosses vacation. Therefore, I said, my lords, after vacation, list on June 4th.
This matter, if your lordship's recall was heard. And today they in fact, they're undertaken to finally make submissions on disposal, my lords.
Who obeys to the petitioner?
Mr. Vyas. This is a matter where survey number 13, entire acquisition to the extent of 5 acres, 9 kuntas, has reached till Supreme Court and upheld and held that position was taken long back. Final notification to the 1967 is challenged, my lords. Lordships had heard it completely, my lords. In fact, indicated for a dismissal of the writ petition.
I'll pass it over.
Please.
I forgot, you tell me again.
Lords, regarding the judgment of Revana Siddhappa, my lords.
Just a minute. Which is the first suit? Which was the first suit that was filed?
First suit is between father and
Son.
That was reached Supreme Court and father has got his share in answer of the father. He is dependent in the suit filed by
Now the other suit is filed by
illegitimate daughter. Claims to be
claims, you admit, he admits.
He doesn't file any written statement. Father, who is respondent number.
No. He had said that MC Akideva. So he admits
He
the.
admits my marriage admits by the plaintiff.
No, he admits the second marriage also, illegal marriage.
Even if it is admitted, the suit is not maintainable. It is my case. For that, a recent judgment passed by Supreme Court, we have gone to. Now, the only question this honorable court has asked me that though she is an illegitimate child, she has got a share in her father's property, or the share allotted to him in the ancestral property, which becomes self-acquired property of the father. Now, once the share allotted to him, the father, then it becomes self-acquired property of him. Now, during his lifetime, the illegitimate child or legitimate child cannot seek partition of the self-acquired property of the father. That is my.
The suit is not barred by law. They may not get the relief. The suit will not be barred by law.
That is affirmed by this Supreme Court judgment. Kindly produce. Page 14 of the judgment. Second paragraph. And the partition of an ancestral property, the property falling in the share of.
Page
14.
para.
Second paragraph. And the partition of.
ಯಾವ ಪೇಜ್ ನಂಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. I have 2023-10 SCC page 1.
Yes. In the paragraph,
Head notes ಬಿಡಿ, relevant paragraph ತೋರಿಸಿ, head notes ಬೇಡ.
Relevant paragraph, this paragraph is very important.
That paragraph, go to the main paragraph of the judgment, don't go by the head note.
78 and 78.
Yes.
There is a degree of contradiction in the referring judgment in Revana Siddhappa, which needs to be clarified and set at the rest at this stage. The two-judge bench has, on the one hand, specifically noted that the prohibition contained in section 16 subclass 3 will apply to such children
with respect to property of any person other than their parents. Emphasis in original. The code has also noted that in case of joint family property, such children will be entitled to a share in their parents' property, but they cannot claim it on their right. The code then holds that logically on the partition of an ancestral property, the property falling in the share of the parents of such children is regarded as their self-acquired property, self-acquired and absolute property, and there is no reason why such children will have no share in such property since they are equated under the law with legitimate offspring. At the same time, during the lifetime of the parents, such a child cannot seek partition. Moreover, the right is confirmed to the property of their parents.
This was the decision Raymond Siddhapa's case.
That has been affirmed by this judge. Impliedly affirmed. That's what it says in the para.
Next read para 79.
From the above observation, it appears that the court in Raymond Siddhapa has recognized that while conferring legitimacy in terms of subsection 1 or subsection 2 of section 16 to children born from void or voidable marriages, the Parliament has circumscribed the entitlement to the property of such children by observing that nothing contained in those provisions shall be construed as conferring a right in or on the property of any person other than the parents. Having noticed this, the court has also observed that in the case of joint family property, such children will be entitled only to a share in their parents' property, but cannot claim it of their own right, as consequence of which they cannot seek partition during the lifetime of their parents. However, the court has also observed that once such children are declared as legitimate, they will be on par with other legitimate children. The observation in para 29 of the referring judgment in Raymond Siddhapa that a child who is confirmed with the legitimacy under subsection 1, subsection 2 of section 16 will be on a par with the legitimate children is in the context of recognizing entitlements of such children, such child in the property of their parents and not for the property of the third person. This is the confirmation, because even if a legitimate child is also not entitled to claim a share in the father's or parents.
This is your defense.
This is the judgment. That is now
Now, according to your understanding, in the share of Sampangi Ramaya, they will not be entitled to any share?
The share of Sampangi Ramaya, the plaintiff is entitled along with me when Sampangi Ramaya is not alive, because it's a self-acquired property.
Is it for you to say or is it for them to say? You are not arguing on behalf of Sampangi Ramaya.
Sampangi Ramaya is also part of the suit.
You are not arguing on behalf of Sampangi Ramaya here. Then
now the suit is my.
I can't reject the plaint.
It has to be rejected. Now, as per section 8 of Injunction Act, when a legal aid will get a right in
Those are all claims on merits,
correct.
not a ground to reject the plaint.
Now that is the case. Now, my suit for partition has been decreed. Now
That will be your defense, saying that my share is carved out, you cannot touch my share. That will be your defense.
Now, my share is also not yet carved out. Now, a execution petition is pending. Now, this self-acquired property is not yet separated. At this, even on that count also, the suit is not made. Now, once the father's share is not yet separated and it becomes a self-acquired
Then the suit will be dismissed. I cannot reject the plaint on that ground.
So rejection, why I am seeking some of.
You may seek for so many reasons.
Now, there is a clear case of bar by law. Once section 16 subclass 3, she cannot file a suit for partition in respect of an ancestral property or a separate property of father during his lifetime, which because a illegitimate child is not granted with the is not accorded the power of co-personal. Just his legitimacy, illegitimacy has been legitimate. Now, as a legitimate son, I am a co-personal. Now, as a co-personal.
That is your defense, sir, saying that.
It is law, it's not my defense, it's an admitted fact by them also. My mother's marriage is admitted. They admit that the suit scheduled properties are ancestral joint family properties in the plaint. Once in the plaint, admission of the fact is admitted that the suit scheduled properties are joint family and ancestral properties. Then how the suit is made to the is the question. Now, once it is admitted by the party of the plaintiff that the suitable property is ancestral property, and a marriage has been taken between his her father and a defendant, respondent number 2. And I am the respondent number 1 is the son of that marriage, and she also admits that a suit was filed between me and his father. It was decreed, and she has challenged that suit also by filing RSA. That suit, because of the filing of the suit, that appeal RSA has been disposed of by the Honorable Court, reserving the right for both the parties to agitate their defense and claim in this suit. Now, in this suit, when once a plaintiff admits that the properties are ancestral properties, as a legitimate
This court
during the pendency, during the lifetime of
this
father.
court took notice of the suit that she had filed and said her rights will be adjudicated in that suit.
Her rights she has to get.
Therefore,
Now, I am
so I'll be modifying the order passed in RSA now. If I reject the plaint, then the effect of the order of RSA goes.
No, RSA, there is no right has been given for religion. We have been granted with liberty to whatever we want to take defense of. It doesn't mean that when a suit is filed, I have been enabled to sue as per law. It doesn't mean that I have been authorized to file a suit, which is not maintainable. And now.
No, suit was already filed by the time RSA was filed. You could have put forth this contention in RSA, saying that this suit, this court did not accept it. This court gave him, this court granted them liberty to adjudicate, get the rights adjudicate in the suit that is filed.
Without making any observation with regard to the maintainability of suit.
I am therefore modifying the order in RSA now.
Now, my submission. There is a law, section 16 subclass 3, which says that illegitimate children does not have any right over the access to properties or any other's property. And now, case on the hand, the plaintiff has filed a suit seeking partition of ancestral property, which is barred by section 16 subclass 3 of Hindu Marriage Act. Now, if she is.
It is not barred. They are not entitled to a share.
That is the meaning, because.
Atra meaning angalla. Barred by law andre, the law should bar them from filing a suit. The bar should specifically state.
Any person from filing a suit, it's clearly.
There are several laws which bar the filing of a suit, which bar the jurisdiction of civil court. In such cases.
In this matter, there is no question, just fact has to be, dispute has to be decided on trial, because she admits that the properties are ancestral property. Once she admits that the properties are ancestral property, section 16 prevents her from filing suit in respect of those properties on which she doesn't have any right. She has a right only after the partition has taken place between the father and other co-persons of the family. And after his death, only then she gets a right to file a suit for partition against the other legal heirs who are the legitimate, against the legitimate children of the father. That is the law. As per my, kindly produce the judgment. That's what the judgment says.
Anything else?
I made it permitted to seek adjournment because I may have to.
I granted you one adjournment or reserve.
What's up?
ಆ ಕೇಸಲ್ಲಿ ಇವ್ರು ಹಾಕ್ತಾರಾ? ಇಲ್ಲ. Number 8 ಅಲ್ಲಿ.
20. I have served the notice and earlier she represented.
I am appealing only for 23, my lordship. 23 for R1. Other cases, I don't know that.
Then who appears for Rajeshwari?
Last time she appeared.
ಬಂದಿದ್ದಾರೆ.
Time to.
Shall I pass it over once? ನೀವು ರೆಡಿನಾ?
No, my lordship.
How to serial number
23, my lordship, you can.
ಸೇಮ್
Same
ಪಾಯಿಂಟ್ ತಾನೆ?
Same. Can you give a start date, my lordship, that I mean proxy council that are recording? Look at it.
ಕ್ಲಬ್ ಮಾಡೋಣ, ರಿಲಿಸ್ಟ್ ಮಾಡಿ. ರಿಲಿಸ್ಟ್ ಆನ್.
Three matters in order. ಇದರಲ್ಲಿ 23 delay ಇದೆ, 29 days delay in filing the.
ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ, until I condone the delay, I can't do anything. I'll have it another day, let us see.
23.
23 ಇದೆ.
ಅದ್ರಲ್ಲಿ ಡಿಲೇ ಇದೆಯಾ?
ಅದರಲ್ಲಿ 29 days delay in filing the.
I'll condone the delay then.
9 days.
ಎಲ್ಲಿದೆ? Based on statement of facts filed by advocate for.
ಅಕ್ವೇಷನ್ ಎಲ್ಲ ಆಗಿದೆ ಅಂತ ಎಷ್ಟು
ಅಲ್ಲ, ಐ ಎಫ್ ಡಿಲೇ ಎಲ್ಲಿದೆ? 23 ಅಲ್ಲಿ. ಅವತ್ತೇ ಬರ್ಲಿ, ಅವತ್ತೇ ಮಾಡ್ತೀನಿ ಬಿಡಿ. ಲಿಸ್ಟ್ 3 ಕ್ಲಬ್ ಮಾಡ್ಬಿಡಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ? ಅದು ಮಾಡಿದೆ, ನಾನು ಆರ್ಡರ್ ಏನು ಪಾಸ್ ಮಾಡಿದೆ, ಪರ್ಮಿಟ್ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಅಂತ.
ಡೇಟ್ ಕೊಡ್ತಾರೆ ಕ್ಲಬ್
ಪಾಸ್ ಇಲ್ಲ, ಡೇಟ್ ಲೆಟರ್ ಕಮ್ ಒನ್ಸ್.
ಚಲೋ ಆಯ್ತು.
31,
32 intermode to extend to continue to the next date. So now 8, 23, 30, 31, 32. Yes.
The Lordship had suggested in the event if they are ready to pay 15% interest along with the amount, or they express that 15% is not possible, I advise my client at least to negotiate and bring it to 12%. Or 12% or interest ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ we are ready to take the money, may not let them enjoy the property.
What will happen if I dismiss the revision? What will happen?
ಫಿಫ್ಟೀನ್ ಪರ್ಸೆಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಹೇಳಿದ್ದು ಸರ್, 25 ಲಕ್ಷಕ್ಕೆ 15% ಸೇರ್ಸ್ ಕೊಡ್ತೀನಿ ಅಂತ ನನಗೆ ಇಂಟ್ರೆಸ್ಟ್.
ನಿಮ್ಗೆ ಎಷ್ಟು ಬೇಕು ನಿಮ್ಗೆ ಅದು ಬಿಟ್ಕೊಡಕ್ಕೆ? ನಿಮ್ಗೆ ಎಷ್ಟಿದೆ ಡಿಮ್ಯಾಂಡ್? ನಿಮ್ಗಿರೋದ್ ಭಾಗ ಎಷ್ಟು ಅದರಲ್ಲಿ? ಆಲ್ ಟುಗೆದರ್ ನೀವ್ ಯಾಕೆ ತಲೆ ಕೆಡ್ಸ್ಕೊದ್? ನಿಮ್ ಭಾಗ ಎಷ್ಟಿದೆ? ಸೊ 6 ಲಕ್ಷ ಕೊಟ್ರೆ ನೀವು ಬಿಡ್ಬೇಕಂಗಾರೆ. ಅಲ್ಲಿ ನಿಮ್ಗೆ ಭಾಗ ಬದ್ದು ಅಮೌಂಟ್ ಬರುತ್ತಲ್ಲ, ಅದ್ರ ಮೇಲೆ 6 ಲಕ್ಷ ಕೊಡೋಕೆ ಹೇಳ್ತೀನಿ, ಖಾಲಿ ಮಾಡ್ಕೊಡಿ. ನೀವು ಒಬ್ಬರೇ ತಾನೇ ಬಂದಿರೋದು. You have not challenged ಅಲ್ವಾ?
ಇಲ್ಲ, he has not challenged. In fact, he has also filed a memo saying that he doesn't have objection for the auction and all.
So you take 6 lakhs and give up possession. Pay them 6 lakhs and I'll ask them to withdraw their claim. ನಿಮ್ 3/4 ಭಾಗ ಅಷ್ಟೇ ಬರೋದು. ಅಲ್ಲಿ ಎಷ್ಟು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ? 25 + 6. ನಿಮ್ಗೆ ಎಷ್ಟು ಬರುತ್ತೆ? 25 ಅಲ್ಲಿ 8 ಬರುತ್ತಾ?
8 lakhs.
8 lakhs ಚಿಲ್ಲರೆ ಬರುತ್ತೆ. ಪ್ಲಸ್ 6 lakhs, 14 lakhs ಬಂದಂಗೆ ಆಗುತ್ತೆ. ವಿಡ್ರಾ ಇಲ್ಲ, I'll dismiss the revision. Huh? Correct. You argue. When was the decree passed? Decree ಯಾವತ್ತು pass ಮಾಡಿದ್ದು? You produced it here? Page number? Seven. Seven. You are the first defendant. Property is 30 feet by 17.5, Allah? No appeal against this? No appeal. When was it filed? Fourth of January 2007. 4th of July, Allah? This court commissioner appointed, right? In this court commissioner was appointed?
Yes, madam.
What is that court commissioner? Page number? Major. What is the report? Now page 24 tane report. 24 ಏನು? La Major sir, the report is at page 24 tane. Page 24, I think, is the report. Page 24. This is only a major. Ultimate report is page 20. Cannot be partitioned.
Property cannot be partitioned by means of one as 1/4 share to the petition as to the $1 four subjects with each of the each individual property. However,
Then when was the auction ordered?
After order subsequently, then the first auction was conducted on 25/4/2014. Not my submission will occupy the share. Now before, pursuant to the before page 24. Now, for after market value is not directly.
When was the date of the auction? When was the order passed by the trial court directing auction?
25/10/2014.
25?
10/2014. The first auction took place on 24/5/2014.
Now, when was the order passed by the court? Do you have the date? 25/10/2000 was the first auction.
Yes, my lord. Then again, it was held on 6/9/2014. 6/9/2014.
25/10 ಅಂದ್ರೆ first.
First to 24/5/2014.
24/5.
2014.
Next was 6/9/2014.
6/9/2014. Third one was 17/1/2015.
You were the successful bidder in the third
The
auction.
third auction,
ಎಷ್ಟು?
25 lakhs.
That was challenged?
That was not challenged.
You did not challenge the order of the trial court, which directed the conducting of an auction. There was an order passed by the court directing the property to be sold by public auction. Did you challenge that order? If you have not challenged the order, that means you accept. In the FDP, your party, you are notified. Despite being notified in the FDP, you did not choose to challenge the preliminary decree. So thereafter, in the FDP, an order was passed to auction this property. You did not challenge that order. That is why I said, if you had challenged the order by which the court directed the auction to be conducted, on the ground that the reserve price is not fixed, there is something in what you say. If you don't challenge the order at all, you allow the auction to go not once, thrice. All right. Twenty-three? 20?
It was auctioned at 26,50,000.
Second action was conducted. It was for 17 lakhs.
17.
17 lakhs. Not even that was also did not take place.
Take place ಅಂದ್ರೆ ಏನು?
Out to a deposit model.
ಮಾಡ್ಲಿ. ಇವ್ರು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
Because they are resisted that they.
ಆಯ್ತು, ಬಟ್ ಇವ್ರು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ, 20 ಲಕ್ಷ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ. Yes.
One MD to avoid the participation of the actual participants, only to receive the amount and I have an intention to receive the action process by
Now, what are you trying to say?
But in fact, you have to kindly appreciate. What, on the action conducted subsequently on 6/2014. Not before commissioner and the impose that will not be bigger to deposit an amount of 2,000.
Now we are concerned with the third auction. Conducted on 17th.
Second action, no, I'm not, this is the second action. The third action, no, sorry, this is third action. Third action, he imposes a condition to the action purchase. But the auction purchaser, they require to deposit an amount of 2,000. Now, there was no such order passed before, impose such condition. And you look at action was also by bidding exorbitant amount to hold on the earlier initial amount of this 2,000 was fixed as there are only 2 countries to enroll. Even the date of action also, nobody come forward to enroll their names. Now you have to tell it now, we have exceeded the jurisdiction, or in fact, this is no fault, this is all of us wanted before. How can you correct in March 2015 and impose a condition on the action you are purchasing? There not is purchasing but the process action purchases. That is one aspect. And now, in fact, notifying all these products committed by the court commissioner. And we have very subsequently by the composite report before the court. And I will call my objection. So you also kindly appreciate now when I have filed objection which is before not done, not with the notified to the court commission. The court after conducted the inquiry by summoning the court commission. That was not done by the
What is the order that you are challenging now? In this revision, what is the order that you are challenging?
But that is all after the process under 24.
What is wrong with that order? What is wrong with that?
Initially, outside the immediate court commission report. After the application notice of court, that these are conducted with court commission. Therefore, one of the property substance of the certain section is giving the property, and that of there is no law sometimes of partition act. Therefore, not the respectability closing and not the law level before the judge. And then last case not given. And not given the judgment of the there is no.
Yes.
Now, it not be.
Did not?
Did not do. One part. Of property, the property is but the relevant of data the data 87.
Where is the order directing the auction to be conducted? Where is the order? Have you produced it? The order directing auction to be conducted? Self proclamation idea. Give me a copy of the self proclamation. You don't have the copy of the order of the court directing auction to be conducted?
No, the entire order sheet is there, but unfortunately.
Idea.
Because unfortunately, it is not in a position where it can be read. I probably have to make a type copy of it.
ಅರ್ಥನೇ ಆಗಲ್ಲ ಇದು. No, where is the order by which it was ordered to be sold on 17th? ಮೂರು ಸಲ ಯಾಕೆ auction ಆಯ್ತು?
The bidder did not deposit the amount in the first auction.
Where is the first order by which the court directed auction to be conducted? ನಿಮ್ದು ಅಷ್ಟೇ ಅಲ್ವಾ? ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ. That is the only argument. ಏನಂತ ಅಬ್ಜೆಕ್ಷನ್ ಏನಂತ ಹಾಕಿದ್ರೆ? ಪೇಜ್ ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅದು ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಬಗ್ಗೆ? Have you raised objection regarding non-fixation of a reserve price? No, this is on page 33 to the commissioner report. ನೀವು ಅದು objection ತಗೊಂಡ್ರ ತಗೊಂಡಿಲ್ವಾ?
ಇಲ್ಲ, they
Reserve
have not
price-
taken that contention.
To the commissioner's report, did you take the objection that reserve price was not fixed, therefore the sale was bad? Did you make an application for setting aside the sale on the ground that the sale was vitiated by irregularities? Without making an application to set aside the sale on the irregularities in the conduct of the sale under order 21 rule 90, you cannot object to the issuance of a sale certificate.
After the last action, not I filed my objection. Not kindly look at my.
Did you file an application to set aside the sale?
But by then, the sale was confirmed.
The moment the sale was conducted, you had the right to make an application order 21 rule 90 to set aside the sale on the ground of a material irregularity in the conduct of the sale. You have not done that. If you have not made the application, how can you challenge the sale? The sale becomes final insofar as you are concerned. You had the right to make the application. When in his application filed for issuance of a sale certificate,
I filed my objection.
there is no requirement of conducting an inquiry on objection to the court commissioner report. You had the right to file an application order to 21 rule 90. That you have not exercised. Therefore, the sale becomes final as far as you are concerned. The sale is confirmed. Automatically, then sale certificate has to be issued. The revision is only against issuance of a sale certificate. This was a sale which was not challenged. ಅದು ಸಾಲಲ್ಲ ತಿಮ್ಮಯ್ಯನವರೇ, ಅದು ಸಾಲಲ್ಲ. Yes. ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ, ಅದ್ರಲ್ಲೂ ಏನು ಹೇಳಿಲ್ಲ. You have to make an application to set aside the sale. ಸುಮ್ಮನೆ mandatory ಅಂತ you can't keep quiet. Suppose 25% amount was not deposited. Then you had a chance to argue that the sale itself was non-est. 25% is deposited. The remaining 75% is deposited. You do not make an application to set aside the sale. You do not object to the order directing the auction to be conducted. Then what is this that you can do now? Still, va? $230. $230. $230. Or else I'll dictate the order now. Your choice. Then I'll dictate the order right now. Bani.
That was not listed on the other day.
For the respondent. Deposit ಮಾಡಿದಿರಾ ಅದು? Deposit. Other 50.
They have made another claim.
Sir, 306 code. $1,14,158. ಇದ್ರಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದ್ರಾ?
ಎಲ್ಲದರಲ್ಲೂ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ.
That is 15,660. No. You have to pay from 3/11/2020, na? La from 1/10/2021.
Pay another 63,000 deposit. That is the balance 50%.
Now, the order that I passed in the other cases was that you pay 50%. And shall also deposit that rupees so and so per quarter. And also pay the remaining amount per quarter, 15,060.
I have to pay. This amount is claimed with others, I am to deposit that.
Same order.
Same order. And in addition to that, I continue to pay the maintenance status for the from 1/4 to 24.
It's pending disposal of this revision. The petitioner shall deposit the remaining 50% of the decretal amount. That is rupees so and so. And he shall also deposit
2,03,580.
2 lakh
3,580. That is the amount they are claiming from
9,000 3,000 9,000 3,000 2,03,000 ಅಂತಾರೆ ನೀವು or 2,09,000 ಅಂತಾರೆ.
Decretal amount, full amount has to be paid.
That
So
is-
far as subsequent is concerned, other day your lordship has directed,
No,
whatever the.
his memo is 2,03,000. Yours is 2,09,000, which is the correct amount.
Not, in so far as I have got a complete figure. So as CRP number 56 is concerned,
No, with 306.
306 is concerned, my lord, the decretal amount is 1,21,796 along with the interest, 23,345. Then subsequent dues, my lord, 2,03,580 and interest of 15,660, which is a subject matter of this thing. Totally 3,64,381 they are supposed to pay in CRP 306.
What the lordships have ordered. Amount, principal amount is there, 2,03,580. That is the subject matter of another suit which is pending with auction. That particular amount I deposit before this on. In addition to that, from 1/4/2024 to 30/6/2024, I am going to pay 15,260. So lordship asked for that clarification, why the 6,000 rupees? The 6,000 rupees is the penalty which they are claiming, which they are disputing.
deposit a sum of rupees 2,03,580. Being the maintenance charges due for the period 1/10/21 to 31/3/2024. On such deposit being made, the registry shall invest the same in a fixed deposit. Next paragraph. The petitioner shall also continue to deposit a sum of rupees 15,660 every quarter till the disposal of this revision.
Not number submission. This decretal amount, they are disputing on the decretal amount. Decretal amount has to be paid fully because
50% they have deposited now, 50% have directed them to deposit.
if they have not paid the full amount as per the decretal, even the 50%, they have not paid the full amount. They have calculated their own calculation without considering the decretal amount.
What was the amount due?
1,14,158 was the decretal amount
40,000 allotment.
plus interest.
My lord, 1,21,796 decretal amount.
Decretal amount is
Decretal amount is 1,21,796.
50% of more than that amount.
That apart, court has granted 23,345 interest.
no. Come to page 33. The decretal amount in CRP 306 is 1,14,158. He says he has deposit 50%. I've asked him to deposit the remaining 50%.
What was the
My lord, 140 is only the principal amount. Court has decreed the cost has also been granted. That has not been
First,
included.
let him deposit.
My lord,
Adyavati the suit, you can move this revision after the suit is disposed of.
SC 969. The world.
Yeah, suit disposed of, move this revision.
Tommy?
After the suit is disposed of, move this revision.
Okay. There is no, my lord, there is no stay on this suit as far as lower court is concerned.
Which stay?
No.
Stay has been granted. I am not asking also. I can't even ask for stay.
CRP 306 Matra on says. Interim order granted earlier, continue. I'll have it next week.
Tomorrow.
Yes, sir.
Not a make tomorrow.
Tomorrow.
Madhyana.
Not versus the qualification. I not in fact in versus the fact.
ಯಾವ್ದ್ರಲ್ಲಿ
Hindi teaches some.
ಅನುಕೂಲ ಮಾಡಿದೆ ಅಲ್ಲ ನಿಮ್ಗೆ. I allowed the petition ಅಲ್ವಾ? ಹಾ.
They have other qualification evidence.
Where is it in relation to these two people? No, in the order.
The right of these controversial facts to be appropriate direct responsibility. All the petitioners except number 7.
Where have I said that they are not entitled? Other? ಏನಕ್ಕೆ? Is the reason that I said? Because it was admitted ತಾನೆ. It was admitted that they were ineligible. No, but you only said except two people.
They not possess that. They have the other qualification. It's stated in the evidence.
You were the ones who said whatever you said, I accepted and moved. Not a ground for review, Alba. Is there a ground for review? Take notice, let us see.
Yes, my lord.
AJ to take notice for
For respond but 2 and 3, my lord.
2 and 3. MR Sinchana to take notice for R1.
R1. R5 to 78, my lord, Vinayaka B as represented in.
Yaru?
R5 to 78, Vinayaka B.
Vinayakana.
Vinayaka B as represented, my lord, in the writ petition.
We
In the writ petition, my lord, it is stated.
petitioners ga.
Allah, respondents, they are also the respondents. This is the petitioner's review petition. R5 to 78, Vinayaka B. The lordship found on page 44, my lord.
Vinayaka B to take notice for respondents
5 to 78, my lord.
78.
And
Naga
5 to 77, my lord.
It is in this.
78 is Shiva Yogesh Yogimat.
78 gyara?
Shiva Yogesh Shiva Yogimat.
Shiva Yogesh, Shiva Yogi Mat to take notice for
79 served, my lord, unrepresented.
Nagayana.
Allah. Respond number 4, my lord. Nagaya. Karnataka Residential Education Institutions.
Nagaya for R4. What about R
79 served, my lord, they are unrepresented.
notice to R79 is dispensed with, released on. If they agree, that is all.
Next matter also same, my lord.
Same. Club Mamudir. For your lordship of the land users. In prayer and writ petition. This was upheld.
ಅದು ಅಪೆಲ್ಡ್ ಆಗಿದೆ ಅದು
Supreme Court. Second, the first prayer in Annex Sheriff.
The evidence has been taken by the and the documents have been produced. Now, what happened is the only first line is over feet and feet circumference. How they are used to pay 25 feet from one side and 55 feet. For which they are not paying compensation. They are calculated only from the pipelines.
ಇಲ್ಲ
So, our justice is incorrect. The pipeline, the circumference of the pipeline is only 3.5 and it is. Now, they are wanted to take to repair, they make a road by the both sides of the.
ಇಲ್ಲ ಫುಲ್ ಪೇಮೆಂಟ್ ಆಗಿದೆ ಫುಲ್ ಪೇಮೆಂಟ್ ಆಗಿದೆ ಅದು ಏನು ಅಕ್ವಿಷನ್ ಅಂತ ಮಾಡಿರ್ತೀವಿ.
For laying the pipeline, you pay 10% of the market value.
ಹೌದು.
But is there a direction by you that you can form a road there?
ರೋಡ್ ಫಾರ್ಮ್ ಮಾಡ್ತಿಲ್ಲ, ಫಾರ್ ಮೇಂಟೆನೆನ್ಸ್ ಓಡಾಡ್ತಾರೆ ಅಷ್ಟೇ. ಅದು ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ಬೋದು ಅಂತ ನಾವು ಹೇಳಿರೋದು. ಅದ್ರಲ್ಲಿ ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ಬೋದು ಅವರು.
Cultivate ಮಾಡ್ಬಿಟ್ಟು ನೀವು ಅಲ್ಲಿ if you are using that road for transport.
ವೆಹಿಕಲ್ ಮೂವ್ಮೆಂಟ್ ಏನಾದ್ರು ಲೀಕೇಜಸ್ ಏನಾದ್ರು ಇತ್ತು ಅಂತ ಚೆಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ.
ನಮಗೆ ಆ ಕ್ರಾಪ್ ಏನಾಗಬೇಕು ಅಲ್ಲಿ ಬೆಳೆದಿರೋದು?
They will be not traveling in the ವಾಕ್ ಮಾಡ್ಕೊಂಡು ಓಡಾಡ್ತಾರೆ ಅನ್ಸುತ್ತೆ. ವೆಹಿಕಲ್ ಯೂಸ್ ಮಾಡಿ ಓಡಾಡಲ್ಲ. Certain.
Why do you need 25 feet on both sides if you have to walk?
ಅಲ್ಲ ಆಕ್ಚುಲಿ ಅದು ಏನಾಗಿದೆ ಮೇಡಮ್, ಡ್ಯೂ ಟು ಇನ್ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಯಾಕಂದ್ರೆ ಅಕ್ವಿಷನ್ ಮಾಡಬೇಕಾದ್ರೆ ಎಷ್ಟು 25 ಫೀಟ್ ಅಂತ ಏನಿರುತ್ತೋ ಅದು ಅಷ್ಟಕ್ಕೂ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿರೋದು ಫುಲ್ಲು.
ಎಲ್ಲಿ ಅವಾರ್ಡ್ ತೋರಿಸಿ.
Right line ನಮ್ದೇ both sides ಲ್ಯಾಂಡ್ ಅನ್ನು ಉಪಯೋಗಿಸ್ತಾರೆ, ಅಲ್ಲಿ ಏನು ಮಾಡಂಗಿಲ್ಲ, ಏನೂ ಬೆಳೆಯಂಗಿಲ್ಲ. ಆಮೇಲೆ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಅಫೆನ್ಸ್ ಅಂತ ನಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಆಗ್ತದೆ.
Lord, is it page number 42? 3436. ಅದೇ ತಾನೇ first?
ಇದು
3436.
district judge. Where is the Act of Petroleum Minerals?
Tuesday notification is there.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಆ notification ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. ಅವರು
ಅಲ್ಲ ನಾನು ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅದೆಲ್ಲ ಕೊಟ್ಟೆ ಹಾಕಿದೆ.
notification ಅಲ್ಲಿ
ನೋಟಿಫಿಕೇಶನ್ ಅಂತ ನಂಗೆ ಯಾವ್ದು ಇಲ್ಲ.
ಇಷ್ಟು ಪೈಪ್ಲೈನ್ ಅಷ್ಟಕ್ಕೆ ಇದು ಮಾಡಿ. Whereas in agriculture lands is concerned, they need to take more than one hectare. For which we are asking for compensation under the Land Acquisition Act.
But page number 49, my lord, in WP 3436. ಅದು in the 9th para ಎಷ್ಟು ಗುಂಟೆ ಅಕ್ವೈರ್ ಮಾಡಿದೀವಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. One submission I would like to place it on record, madam. In similar matter, this one of the case, there is a batch of matters, my lord. In one of the case, this petition has already been now file ಮಾಡಿದ್ದು, ಕಾಂಪನ್ಸೇಷನ್ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ರು, ಅದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಹಾಗಾಗಿ ಅದ್ರ ಮೇಲೆ SLP ಫೈಲ್ ಮಾಡಿದೀವಿ. ಯಾಕಂದ್ರೆ ಅದು ಒಂದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅಂತಂದ್ರೆ
ಇದನ್ನು ತಗೊಂಡೋಗಿ SLP
ಅಲ್ಲ
ಕ್ಲಬ್ ಮಾಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ ಮೇಲೆ
ನಾನು ಜಾಸ್ತಿ ಮಾಡಂಗಿದ್ರೆ 2 ಒಟ್ಟಿಗೆ ಆಗುತ್ತಲ್ಲ.
ಅಲ್ಲ ಮತ್ತೆ ಅದು ಯಾಕಂದ್ರೆ ಸುಮಾರು ಬ್ಯಾಚ್ ಆಫ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಜಸ್ಟ್ ರೆಕಾರ್ಡ್. ಸದ್ಯಕ್ಕೆ ಅದು ಅಲ್ಲಿ ಸ್ಟೇ ಅಂತ ಆಗಿದೆ, ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್ ಅಂತ. It may be likely to be listed in the month of June, my lord. ಅದರಲ್ಲಿ ಅಲ್ಲಿ.
ಅದರಲ್ಲಿ what is the 25 feet that is talking about?
ಅಲ್ಲ ಅವರು 25 feet ನಾವು ಇದ್ ಮಾಡಿದೀವಿ ಅಂತ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು, ಬಟ್ ಕಾಂಪನ್ಸೇಷನ್ ಬರೀ 5 feet ಗೆ ಆತರ ಎಲ್ಲೂ ಪ್ಲೀಡಿಂಗು ಇಲ್ಲ, ಅದು ಬಂದು ಇಲ್ಲ ಆಮೇಲೆ. ಅಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಇದ್ರೆ ಕೊಡಿ, ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಇಲ್ಲಿ, ಅದಕ್ಕೋಸ್ಕರ ಯಾವ್ದ್ರಲ್ಲೂ ಒಂದ್ರಲ್ಲಿ ಕೊಡಿ, ಎಲ್ಲ ಒಂದೇ ಇರುತ್ತೆ.
ಎಲ್ಲಿದೆ ಸೀತಪ್ಪನವ್ರೆ ಅದು 25 ಅಡಿ ಆ ಕಡೆ ಅಂತ? ಹಾ,
3x3 ಹೀಗೆ ಅವ್ರಿಗೆ ಬೇಕಾಗಿರೋದು ಲೈನ್ ಹಾಕೋದು. ಈಗ ಅದು ಪಕ್ಕದಾಗ ಇರೋದನ್ನ ಲ್ಯಾಂಡ್ ಯೂಸ್ಗೆ ಉಪಯೋಗಿಸ್ತಾರೆ, ಅದು ರಿಪೇರಿ ಮಾಡಕ್ಕಂತೆ ಓಡಾಡಕ್ಕೆ ಅದಕ್ಕೆಲ್ಲ ಇಟ್ಕೊಂಡು.
ಅದು ಎಲ್ಲಿ ಸಿಗುತ್ತೆ?
ತರಿಸ್ತೀನಿ ಮೇಡಮ್.
Does the act of the rule state as to what is the extent of the land?
ಆ ಗ್ರೌಂಡ್ ಎಲ್ಲೂ ತಗೊಂಡಿಲ್ಲ, ನಮ್ಮ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಕೂಡ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ನಾವು 5 feet ಮಾತ್ರ ಕಾಂಪನ್ಸೇಟ್ ಕೊಟ್ಟಿದೀವಿ, ಬಟ್ 25 feet ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂತ. Pleading to that effect, there is no pleadings also.
24 ಗುಂಟೆ ತಗೊಳ್ಳೋದು 24 ಗುಂಟೆ ಹೇಳಿ.
But compensation is paid for 23 guntas only. ಎಷ್ಟು
ಪೈಪ್ಲೈನ್ ಅಥವಾ
for maintenance ಅಂತ ಮಟ್ಟ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Section 10 exact says that. With the pipeline passes.
But section 9 restricts the right to use the land, construct any building or near the structure, construct or excavate any link, well, reservoir or dam, or plant any tree.
ಅಲ್ಲ ಟ್ರೀಸ್ ದೊಡ್ಡ ಮರಗಳಾಗುವಂತದಕ್ಕೆ ಪೈಪ್ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ ಅಂತ.
That means you're
ಬೇರೆ ರಾಗಿ ಜೋಳ ಇನ್ನೊಂದು ಆತರ ಕ್ರಾಪ್ಸ್
you will dictate how they have to use the land.
ಅಲ್ಲ ಆ ತರದೆಲ್ಲ ಮಾಡಬಹುದು ಅಂತ.
Therefore, you're depriving them. Suppose it is easier for them in regard to the soil to have mango plantation or coconut plantation.
ಅದು ಟ್ರೀಸ್ ಎಲ್ಲ ಹಾಕ್ಬಾರ್ದು, ಪೈಪ್ ಡ್ಯಾಮೇಜ್
So
ಆಗುತ್ತೆ.
that means you're virtually acquiring the entire land, isn't it?
To understand, my lord.
Then?
Just waiting for Supreme Court decision. So ಅದು ಒಂದು
Supreme Court leave point is ಆದ್ರೆ ಇದ್ರ ಇಲ್ಲ ತಾನೆ.
ಇಲ್ಲ ಸೇಮ್ ಎಲ್ಲ ಸೇಮ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಮೇಲೆ there are.
25 feet other than
ಇಲ್ಲ ಅದರದೆಲ್ಲ ಇಲ್ಲ ಅದರಲ್ಲಿ. ಅಲ್ಲ ಇಲ್ಲೂ ಪ್ಲೀಡ್ ಮಾಡಿಲ್ಲ, ಇದ್ರಲ್ಲೂ ಪ್ಲೀಡ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ.
No, I'll take judicial notice. Suppose you are asking them not to plant any tree. For that also I'll award compensation. ಅದನ್ನು ತಗೊಂಡೋಗ ಅದು ಡಿಸೈಡ್ ಆಗ್ಬಿಡ್ಲಿ.
ಸ್ವಲ್ಪ ಅದು ಅವಾಯ್ಡ್ ಆಗಿ.
No, if you're curtailing the use of the entire 22 guntas of land. So you're basically dictating that you can only grow this. Suppose they can't grow paddy or ragi or whatever. Given that soil condition. And they can't plant a mango plantation, cashew, arecanut.
ಹೌದು ಆ ತರದೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ.
Then
What
because the order indicates that you removed some trees also. They're existing there.
ಅದಕ್ಕೆಲ್ಲ ಕಾಂಪನ್ಸೇಷನ್.
So that was the use that land was being put to before.
Yes.
No, they can't use the land for the same purpose.
Not for you. ಅದು
Then
ಟ್ರೀಸ್ ಎಲ್ಲ ಪ್ಲಾಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ. I do understand, my lord, but act says like.
no, if you restrict the right to plant any tree, for that I'll give extra compensation.
Short accommodation, my lord. ಯಾಕಂದ್ರೆ in the meantime let the judgment come, my lord, so that ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಅಂತ. That's what we are.
ಇಲ್ಲ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ನಿಮ್ದು SLP dismiss ಆಯ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ, ಅಲೋ ಆಯ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ. Your right to claim compensation will still remain.
ಕೊಡ್ಬೇಕಾಗುತ್ತೆ, ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
Suppose ನಿಮ್ದು ಅಲೋ ಆಯ್ತು ಅಂತಂದ್ರು ಸಹ ಇವ್ರದ್ದು I can still decide as to whether that restriction for use of the land for planting trees.
ಕಾಂಪನ್ಸೇಷನ್ ಜಾಸ್ತಿ ಮಾಡಿದ್ದಾರೆ ಆ ಕೇಸಸ್ ಅಲ್ಲೆಲ್ಲ.
ಇಲ್ಲ ಅದಲ್ದ್ರೆ ಇನ್ನು ಸಾಲದು ಅಂತ ಬಂದಿರೋದವ್ರು.
ಸಾಲದು ಅಂತ ಬಂದಿರೋದು.
Suppose I accept their contention that the right of theirs to plant a tree is curtailed, for which they deserve a compensation. Then
acquisition ಅಂತ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. I will have a word with the official.
maybe ಪೂರ್ತಿ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು
I will put across to the company, my lord.
50% of the market value or 30% market value is what I'm thinking.
ಹೌದು, ನಾನು ಮಾತಾಡ್ತೀನಿ.
If you allow them to plant trees,
Then
then that will not be there. If you don't want them to plant any trees, then there must be a consequence.
Just will put across to the amend, then we'll make submissions.
Next Monday.
ಆಗ್ಬೋದು. Otherwise, ಅದು ಅವಾಯ್ಡ್ ಮಾಡೋದು ಸ್ವಲ್ಪ ಬೇಕು. ಒಂದು ಸೆಕೆಂಡ್ ಅಲ್ಲಿ.
Sale deed.
Cancellation of allotment.
Well, my lord, the allotment was cancelled as per the, my lord, the annexure A. My lord, the resolution, my lord, they made the representation to the BDA stating that we have utilized the land for the formation of the road without acquisition. My lord, on that base, my lord, on the report of there is an earlier report, my lord, by the engineer, executive engineer, that we have not formed the road in that area. We have even not formed the layout also in that area. Subsequently, the surveyor, my lord, and the ADLR made the surveyor and
Whatever be on the merits, a sale deed is executed.
sale deed is executed.
How can you cancel the allotment?
My lord, the site was allotted as per the resolution of the BDA.
So-
That resolution was subsequently recalled, my lord. That recalling the resolution was attained finality.
Sale deed is also attained finality.
Yes, but the
Then-
allotment itself is on the base of the resolution. That resolution was set aside,
But-
recalled.
Sale deed and meaning Krishna.
Sale deed is concerned, my lord, they have to file the suit. But the only thing is, my lord, it is the fraud. The site was obtained on the base of fraudulent acts.
But as per the resolution, they have been stated.
That resolution is now
And has been utilized.
that resolution is recalled and that attained finality, recalling.
ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಸೇಮ್ ಅದೇನಾ?
ಹೌದು, ಮೂರ್ನಾಲ್ಕು ಸೇಮ್. But my lord, the allotment is on the base of resolution. That resolution was recalled and that attained finality. The sites are obtained on the base of the fraudulent act, my lord. The fraud is.
So you will have to file a suit for cancellation.
Cancellation of sale deed is concerned, my lord.
On the ground that it was obtained by fraud or whatever you want to do, you can do. But how can you cancel the allotment?
My lord, the allotment, we can cancel by the.
ಹಿಂಗೆ.
My lord, the allotment was made on the base of the fraudulent act by passing the resolution.
Allotment is inconsequential. The moment the sale deed is executed. Allotment is till the execution of the sale deed, I am allotting you this site. And I convey the site to you at a later date. Once the sale deed is conveyed, property is conveyed, then what remains for you to
But
cancel?
the allotment itself is a fraudulent act, my lord. The fraud vitiated everything, my lord.
Take upon some of the report. There was, they have to approve these reports. 41, 42. 41, 44, 44, maintainability.
1194 is the resolution, huh?
One more.
Allotting 6 sites.
1194,
All sides are
1194 resolution.
6 sites, alva?
No, 6 ಅಲ್ಲ, 12 sites, my lord.
6 petitioners are there.
12 sites, sir.
12 sides have been allowed.
12 sites, huh?
12 sites,
To 6 brothers.
6.
Serial number 15, huh?
Serial number 15 of Umar and
25 guntas.
25 gunters were required.
Not 25, my lord, 15 guntas.
What is the date of the sale deeds? ಇದು ಒಂದೇ ದಿನಾನ sale? ಎಲ್ಲ ಒಂದೇ ದಿನಾನ?
ಅದೆಲ್ಲ ಒಂದೇ.
1st of June 95.
dates. 17th May ಗೂ ಮಾಡ್ಬೇಕು. ಕೆಲವು ಬೇರೆ petition. But, dates are-
ಅಷ್ಟೇ ಅಲ್ವಾ?
My lord, with the liberty maybe.
ಏನಕ್ಕೆ?
That is the judgment, my lord, where when the sale deed is, cannot be cancelled unilaterally, we have to approach. But here only difference is, my lord, this is a act of fraudulent act, my lord, therefore the fraudulent.
1/1/1984. The BDA passed a resolution proposing to allot 12 sites measuring 20 by 30 to the petitioners, bracketally 6 brothers, on the ground.
Respect of 2 more petitions, not court notice one issue. But so far as the court matter is concerned, not petitioner is no more. During the, before the recovery court collapse, the legal hands were brought on the court. But now once he is no more and they are not part of the court.
You will take notice.
And ಎಲ್ಲಾರ್ಗೆ court notice ಹೋಗಿದೆ, but ಅಲ್ಲಿ address ಯಾರು ಇಲ್ಲ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
If you take notice, I will accept it. And inherited petition ಯಾವುದು?
ಇನ್ನೆರಡು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, but 2 more petitions.
ಯಾಕೆ ಲಿಸ್ಟ್ ಆಗಲಿಲ್ಲ? I'll dispose of altogether. No, others also I'll get in dispose of. 3 ಇನ್ನೊಂದ್ಸಲ ಹಾಕಿ. On the ground, ಏನು ಹೇಳಿದ? The BDA had utilized their land bearing survey number 25, measuring 25 guntas for the formation of an 80-feet road. Next, pursuant to the said resolution, registered sale deeds were executed in the year 1995 in favor of the 6 brothers. Next, however, thereafter, one G. Ravi made a claim for allotment of land, allotment of sites on the ground that his land bearing survey number 9/1 and 10/1 had also been utilized by the BBMP. BBM by the BDA. The BDA overtook up the contention that there was no documents to establish that a road was formed in his land and proceeded to reject his claim.
Even BDA claimed that we have not farmed the road. It is the.
That's what I'm saying. As against this rejection of the said claim, comma, it appears that the said Ravi approached the Upalokayukta contending that sites had been allotted to the petitioners for utilizing their land bearing survey number 15 for the formation of the road, whereas he had been discriminated against, though a road was formed in his land bearing serial number 9/1 and 10/1. On the basis of an oral direction by the Upalokayukta, the matter was considered by the authority, and ultimately the authority proceeded to reject the claim on 12/3/2014. The Upalokayukta, however, was of the view that the resolution of the BDA in rejecting the claim of G. Ravi while granting the claim of the petitioners would be incorrect. And in the light of this observation of the Upalokayukta, the authority proceeded to pass a resolution on 5/7/2014, rejecting the claim of G. Ravi, and at the same time, it also proceeded to withdraw the resolution that had been passed in favor of the petitioners on 1/1/1994. The authority thereafter, the commissioner thereafter proceeded to issue the impugn order informing the petitioners that their allotment had been cancelled. Next part. A reading of the impugn order would categorically indicate that the BDA had in fact executed registered sale deeds in favor of the petitioners in the year 1995 pursuant to the resolution passed on 1/1/1994. Next para. By virtue of these, by virtue of these registered sale deeds, whatever title the BDA possessed over the said sites stood conveyed to the petitioners, and once the title of the BDA stood conveyed, the question of the BDA cancelling the allotment would never arise. In that view of the matter, the impugned order by which the allotment made in favor of the petitioners pursuant to the resolution dated 1/1/94 cannot be sustained and is accordingly quashed. It is needless to state that if the BDA is of the view that the allotments are fraudulent and that the sale deeds are required to be annulled, it would be at liberty to approach the appropriate civil court seeking for appropriate reliefs regarding the conveyance already made by them. Subject to the above, writ petition is allowed. In ಎರಡು ಬರುತ್ತಲ್ಲ ಅದನ್ನು CS ಮಾಡೋದು. ಇನ್ನು unnumber ಅಂದ್ರೆ ಎಲ್ಲ ಇದೆ ಅಂತ ಚಂದ್ರಶೇಖರ್, ಆಲ್ 6 are
ಇಲ್ಲ, ಎರಡಿದೆ. 8 ಅಲ್ಲ WP
ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ WP 8361 of 2015 ಮತ್ತೆ 9710 of 2015. ಎರಡು.
ಇಲ್ಲ ನೀವು ಒಂದ್ ನಂಬರ್ ಕೊಡೋದು LB ಅಂತೆ.
ಇಲ್ಲ 8361 ಮತ್ತೆ 9710 61
ಇದೆ ನಂಬರ್. ನೀವ್ ಹೇಳ್ತಿರೋ ನಂಬರ್ ಯಾವ್ದು?
8361 of 2015 and 9710 of 2015.
9710.
10 of 2015.
Where's Nayak? And if he agrees it is covered, I can take it up. Or else if he says it is not covered, ಅವ್ರು ಒಪ್ಕೋಬೇಕಲ್ಲ.
Where's serial number?
Lord, serial number.
ಡೇಟ್ ಕೊಡ್ತಾರ ಅವ್ರು.
Serial number.
ಬಟ್ ನೋಡ್ರಿ ಆದಾಗ ಮಾಡಿದ್ರೆ 65 ಮ್ಯಾಟರ್ ಆಗ್ಬಿಡುತ್ತೆ, ಯಾವ್ದು ರೀಚ್ ಆಗಲ್ಲ. ನಾನು ಮಂಡೆಗೆ ಹಾಕೊಂಡಿರ್ತೀಗ ರೀಚ್ ಆಗಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತೀನಿ ನಾನು. ಈ ವಿಲ್ ಗಿವ್ ಯು ಅ ಡೇಟ್ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ದಿ ಅವೈಲಬಿಲಿಟಿ.
My lord, serial number 62, my lord. Serial number 62 is covered, my lord.
Covered by
My judgment of this honorable court by the Shinapa's judgment, my lord. Award is passed in 2022 and under the KD, but it's passed under the old act, my lord.
where is he? Chennai. If he comes here, I'll take it up at 2:30.
2:30.
Serial 45.
Has undergone a surgery.
Kindly out next time. Serial number 40, my lord. I am for respond number 4, my lord.
For the petition, the respond contesting.
What do you want?
Because the hand kindly have next week, because any day. Mind the interim order may kindly be extended.
Serial number 45. Serial number 45 can be have it tomorrow or day after.
What is it about?
It's about development plan.
He'll give you a date 2023. He'll give you a date. 20? Serial number? ಯಾರು ಅಪೋಸ್ ಯಾರು ಮಾಡ್ತಿದ್ದಾರೆ? ಕವರ್ಡ್.
Similar matters are because of the same property itself. This matter should be.
No. Similar matter ಅಂದ್ರೆ ರಿಟ್ ಅಪೀಲ್. He says writ petition itself is referred to DP. He says writ petition itself is referred to DB, similar writ petitions. Date, on date could your
4:30 matters, my lord.
hearing coming group. Very important. Chandrasekhar. ಕರೆಸ್ ಕೇಳಿ ಇದ್ಯಾವ ನಂಬರ್ ಒಂದು ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ಅಂತ ಬಂದು ಬರ್ತಾ ಇದೆ. ಚೆಕ್ ಮಾಡಿಸಿ. No, I'll give dates. I can't give.
4:30.
Who's for the respondents?
For the 4 and 5 in this case, my lords.
Ready na? He says only for a mandamus.
I am like opposing, my lords.
On date.
My lord, 41. Serial number 41.
Yes.
Your lordship may have it tomorrow because the state has got instructions as regards the dispute of measurements with them. State has got instructions, it can be disposed of.
4:30 matters, my lord. 4:30 matters, my lord. The matter has been discussed with the partners by 10 days.
4:30.
CRP matters, my lord. Serial number 17 is second list. Please, my lord, 17 in series. Within, I'm a respondent, my lord. Last date of hearing, my lord, lordships are heard. They have negotiated 2 courts. I've discussed with our partners. Therefore, on 10 days, my time may be request for discussion.
Release.
46 on that.
Serial ಪ್ರಕಾರ correct.
Sir,
Serial
46.
ಪ್ರಕಾರ.
Sir, same time.
ಅಲ್ಲ
Sir,
40. Sir, 40.
ಸರ್ ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ.
40 ಕದಿಲ್ಲ.
ಸರ್ 41 ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ.
ಬೇಡ ಲಾಂಗ್ ಇರ್ತದೆ.
ನಾನು ಪಿಟಿಷನರ್ ಇದ್ದೀನಿ ಇಲ್ಲಿ.
ಹೌದು ಮಾಡಿ.
Sir, now petitioner after vacation, interim order, sir. Sir, interim order is there.
Court officer, sir.
ಸರ್ 59 ಯಾವ ಡೇಟ್ಗೆ ಹೋಗಿದೆ ಸರ್? ಸರ್ 59 ಯಾವ ಡೇಟ್ಗೆ ಹೋಗಿದೆ?
ಯಾವ ವರ್ಷದ್ದು ಅದು? ಯಾವುದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಾ?
Dharwad bench matters. For order serial number 1, Shri Ravi Hegde.
Lord, I am appearing for petitioner. The respondent, my lord, has issued an endorsement stating that they have prepared a writ appeal against the order at Annexure A, page number 8.
What happened to the writ appeal?
Writ appeal is still pending, my lord. It is listed for non-compliance of office objection. There is no stay.
Where is Prashant?
He is not in online, my lord.
Third of June.
Please.
For hearing IA, serial number 2, Shri Ram P. Gorpade. I'm on the petition in the case, Lordship.
Purpose for the state.
The Praveen joined the case.
I'm appear for my lord respondent. I have also filed my lord common objection. My lord, as per complaint, my lord, the accuser or my lord identified by the. Also, my lord, the investigation officer has been seized the articles, stone, my lord.
What is the overt alleged against them?
Lordship, there is no specific overt attack in the present petition, Lordship. There is only specific overt attack in 1 to 4, Lordship.
There
Who
are
the
cooperative.
petitioners?
And already the Lordship, accused number 28 is the Lordship is quashed. It is page number 235.
ಯಾವ number ಅಲ್ಲಿ?
Page number 235, Lordship. For the accused number 28, but in that the accused the enter person is quashed, Lordship. There is only specific overt attack by accused number 1 to 4, Lordship. Only there is the omnibus allegation in the present petition, Lordship.
Accused ಯಾರ್ ನೀವು?
So present accused lordships, the accused number 45, 46, 47, 48, 49, 50 and 51 pertaining to criminal petition number 100704.
Which is the relevant page in the charge sheet against them?
The page number 57, the column number 17 lordship.
Page number?
Number 57. Column number 17 lordship.
This is a revision. This is a petition filed by no case accused number 45 to 51. And accused number 6 to 6, 7, 8, 10. 7, 10 to 15, 20 to 23. More check on. The police registered an FIR for offences under section 143, 147, 341, 332, 353, 427, 149, and section 2A of the Karnataka Prevention of Destruction and Loss of Property Act 1981. Pursuant to the investigation, a charge sheet was also laid against the petitioners herein. In respect of accused number 43, 5 and 6. This court, criminal petition 100-607, 100-675 and 100-677 of 2022 quashed the proceedings on the ground that there were no allegations, no overt acts attributed in respect of the accused therein. Even in respect of the present petitioners, there is no overt act attributed in the FIR or in the charge sheet. I am therefore of the view that there is no justification to continue the proceedings as against the present petitioners. Consequently, the criminal petitions, insofar as it relates to the petitioners that who are arrayed as accused number so and so, shall stand quashed.
For further hearing, C number 3.
Lord, I appear for the petition, Lord.
For respond number 2 CBI.
Very categorically said that they have to prove their ownership. And I've been told that two things are happening. They certain iron ore was seized, which was illegally transported to a port. Post seizure, certain iron ore was stolen from the port, for which another FIR came to be registered. By virtue of the Supreme Court order, that FIR was transferred subsequently to the CBA. And I think I have also been told that some of the petitioners who are petitioners, they are also accused in that case as well. The whole issue, my lord, is that Section 80 of the Karnataka Forest Act makes it an offence to enter the state property.
What was the first FIR registered?
FIR on the 17th of 2009 and the FOC.
Do you have the dates? Do you have the dates on when it was registered?
Yes, my lord, that registered. That's the first FOC registered.
Date?
15/3/2010.
Huh?
15/3/2010.
For offenses under
Karnataka Forest.
section.
Please, sir.
In this, iron ore was seized.
Yes.
Do you have any idea when?
It was seized, my lord, on 20th March 2010.
At Belcare Port only.
Yes. The report was the permission subject to the PS when it was in the custody of the Forest Department.
Then, when was it the second theft?
So in between, certain iron ore, in spite of this iron ore being seized for export, and that crime number 180 of 2010.
Date? Date 40? Purdi ready ಆಗಿಲ್ವಾ?
2/6/2010. 2/6/2010. Kola Constitution crime number. 189 of 2010 on Kola Constitution.
189 of
2010.
ಎಲ್ಲಿ?
ಒಂದು ಹೋಗುತ್ತೆ
Kola.
ಒಂದಕ್ಕೆ ಬರೀ ಸ್ಟೇ ಆಗ್ಬೇಕು.
Test was also when I have been reported to the court permitted them to file a complaint. Subsequently, complaint has been filed for 379.
So there are two FIRs. One is the original under the Forest Act. The other is for this theft of this iron ore which had been seized. This by Angola, which was transferred to CBA.
Crime number 189 was transferred to CBA. So there was some confusion around in between because Samaj Parivartana matter was took up to Supreme Court. Supreme Court said that some of the iron ore, all the iron ore fields, exporting and excavation, they said that it transferred to CBA. Subsequently, they transferred back based on a quantity of iron ore seized. In between, what happened in the crime number FOC number 17 was transferred to CIT by the state government order. By
This, no, transferred to CBA. This was taken up to Supreme Court.
No, by virtue of the Supreme Court order, automatically crime number 189 was transferred. Before crime number 189 was transferred, crime FOC number 17 of 2009 and 10 was transferred to CIT by virtue of the government order.
FOC 17 is transferred to CID. FIR 189 is transferred to CBA. You are saying pursuant an order of the Supreme Court.
ಪಾಸ್ವರ್ಡ್ ತೊಗೊಂಡ್ಬಿಡತ್ತು ನಾಳೆ.
ನಮ್ಗೊಂದು ಸಿನಾಪ್ಸಿಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ, ಇಷ್ಟೊಂದು ಕನ್ಫ್ಯೂಷನ್ ಇದ್ರೆ. Because of the confusion, I asked somebody to.
May I make all the people synopsis and place it?
ಯಾಕೋ ಇದು ಗಳಿಗೆ ಬಂದಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
Because where is this FIR was pending?
No, 10th time it's being adjourned. The list.
Lord, may I request for a date, my lord?
Monday.
Please, obliged.
At least all that, list of dates and
List number 1, passed over matters.
Lord Council of BBMP seeks for a week's time to comply with the order 14/3/2024. Post on so and so. Till then, interim order granted earlier shall continue. Matter was heard last time, isn't it? Thursday. Finally, Thursday. Interim order continue till then. Page number? Yeah, 46 of what? ಅಲ್ಲ ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 46 ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲ ಇದ್ರಲ್ಲ. Yes. Shana? That is why I gave the option of purchasing the property. You could have paid him 12% interest and retained the property. What is the mistake that he did in participating in the auction? Nobody wants to throw you out of the house, but you will have to pay for it. You can't enjoy the property free of cost. If your sisters are prepared to give up, fine. Why should he give up his right? I persuaded him to agree to take the amount back with interest. You're not ready for that also. You will lose the property. That is what else can I do? He has paid 26 lakhs, 25 lakhs, out of which you rented for how much? About 6 lakhs. 4 share ಅಲ್ವಾ 1/4 ಅಷ್ಟೇ ಅಲ್ವಾ ಬಂದಿದ್ದು 1/3 1/4 1/4 ಅಲ್ವಾ ವರದಮ್ಮ ವಿಲ್ ಏನ್ ಮಾಡಿಲ್ವಾ ಒಪ್ಕೊಳ್ತೀರಾ ನೀವು ವಿಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಸೊ 1/3 you rented for how much then? About 8 lakhs. ಹೆಂಗಾಗತ್ತೆ ಹೇಳ್ರಿ ನೀವೇ 25 ಲಕ್ಷ ಅನ್ನೋ ಅವ್ರು ಕೊಡೋದಕ್ಕೊಂದೇ therefore you please then what can I do? They can't pay you having purchased it in the auction for 25 lakhs. Why will they double the amount now? So you are asking them to pay 50% more than what they paid in the auction. Isn't it? 10 ಲಕ್ಷ ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ರೆ 25ಕ್ಕೆ ನಿಮ್ಗೆ ಅರ್ಧ ಜಾಸ್ತಿ ಕೊಟ್ಟಂಗೆ ಆಯ್ತಲ್ಲ ಅವರು. ಆಕ್ಷನಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿ ಏನು ಸುಖ ಆಯ್ತಂಗಾರೆ ಅವರು? ನೀವು ಸ್ವಾಧೀನ ಉಳಿಸ್ಕೊಂಡ್ರಿ ಇಷ್ಟು ದಿನ, ಜಾಸ್ತಿನೂ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಏನು? It won't be fair on my part to ask him to pay so much. If he's prepared to pay, take it. I have no problem. ಏನ್ರಿ? ಇಲ್ಲ ಅಂತಿದಾರಲ್ಲ, ನನ್ ಮುಂದೆ ಅವ್ರು ಒಪ್ಕೋಬೇಕು ತಾನೆ. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ನೋಡ್ರಿ ನಾವು, suppose that order is, no, suppose that order is in your favor, then you will not even argue. I'll just follow that order. ಯಾವತ್ ಮಂಡೆಗೆ ಹಾಕೊಳ್ಳ? First 1.1 who appears for the petitioner there? ಅಲ್ಲ 7441. Then 11535. It stated that WP 11535/2022 is not connected WP 7441 by 2021. Means dealing WP 11535/2022 and post before the regular bench. WP 7441 of 2021 post Monday. ಲಿಂಕ್ ಆಗಿದೆ, ಲಿಂಕ್ ಆಗಿಲ್ವಾ? ಮಂಡೇ
the page, basically not. For age of super examination is 65 years.
ಸಿಕ್ಸ್ಟಿ-ಫೈವ್ ಇದೆಯಲ್ಲ? When were you appointed, madam?
Well, he was appointed on March 13/3/2019.
This will apply then.
Yes. 3/3/2019.
September 2021, he has not been paid the salary and is not allowed to enter the premises.
Yes.
Yes. Plus, he was appointed on 3/3/2019 as an assistant professor. Plus, on 1/2/2021, plus he was given in charge of HOD. He did not plus continued, he resigned to the post of HOD and continued the work of plus assistant professor.
Which is the document to show he resigned?
Well, he did not resign, but he is continued. But I produced the, plus, I did not have it.
One to 2009, one to 2020, he was promoted as a HOD along with the teaching job and administrative. As with Plaint is more having the industrial experience and academic oriented, he was not interested in the administrative job, so he requested to continue him as an assistant professor. So he resigned for the post as the HOD job. And he continued to work as a professor. Then, the Lordship, I humbly with this Honorable Court to kindly come to the page 32, annexure here. Annexure here, page 32 in the page 41 or now, when in the September middle, when he was not allowed to enter the premises, he has tried to reach the chairman, HOD, principal. When they didn't pick the call, he has written all these ways. The number of times he prayed for them to let him know why he was treated like this, and at least at last, when they were not responding, he was repeatedly asking, at least give me my experience certificate and master certificate so that we can search the jobs.
Which is that request?
Lordship, page number 32 regarding petition. Then there is a specific name. Lordship, page number 41.
41.
Page number 40. He continues to operate. And I read out this. This is administrative officer, principal, HOD, and the chairman. Greetings of the day. Sorry to disturb you already. Yesterday I checked my bank account for the September month salary. It is observed that salary is not credited to my account. Kindly check and instruct the concerned person to credit the salary at the earliest. For any of my
Any reply given to this? Any reply given to page number 40?
Orally instructed, plus. Or phone they have replied.
ಏನಂತ?
Over phone, they have replied.
Your Lordship,
Or phone you reply to an email.
Over phone.
ಏನಂತ?
ಇದೆಲ್ಲ ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತೇಳಿ.
ಏನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ?
ನೀವೇ ಅಬ್ಸ್ಟೈನ್ ಆಗಿದ್ದೀರಾ, ನೀವು ಬಂದು ಡ್ಯೂಟಿ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
So therefore you are ready to take him back to duty now.
No, there is no question of Malas. There is no question. Malas, I'll argue the matter. Malas. Let her complete. Let her complete.
Now, head of the department, administrative officer and chairman. ಇದು ಕರೆಕ್ಟ್ ಈ ಜಾಬ್ಸ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಇನ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಹೋಗಿದ್ರು ಅದನ್ನ ನೀವು ವಾಪಸ್ ಕಳಿಸಿದ್ದಾರೆ.
Yes.
So without any resort, we had moved this court earlier, but we didn't make the release. This my right to make the release until and first to fight for legal justice.
So you want to be reinstated?
Option is they want.
Do you think they'll allow you to work there?
Otherwise, let them pay the salary fee now. Your Lordship, petition, ಇದು respondent petition ಹಾಕಿದಾರಲ್ಲ, ಅದರಲ್ಲಿ you see my client is page number 38 ಬಂದಿದೆ. Respondent petition ಅಲ್ಲಿ page number 37, 38. My client has got the master certificate in July 89. After that, he has worked in very good institution, Brigade Group, ಮತ್ತೆ ಇದು B&B estate and infrastructure, ಆಮೇಲೆ ನಾಗಾರ್ಜುನ construction company limited. So he has worked as a deputy project manager.
What is the prayer in your writ petition?
The main prayer is or any other way, our direction to the respondents to allow him to discharge his duty as an assistant professor in the civil engineering department of respondent number 4 institute. And interim prayer to issue a direction to the respondent number 4 and 6 to release his salary from September 2021 till pending the disposal of the above petition. I have two more submission.
Yes.
The respondent in this objections has taken up argument that my client has spoiled the life of one student who is the name is Gagan Gowda. What they are claiming is the petitioner has not given the marks to him in the project, because of which he failed in the final BED. Your Lordship, as a HOD of the civil engineering department, my client was working as a project coordinator. The person who has to give the mark is the course teacher. Course teacher, whatever she has used the marks, he used the thumb to upload that marks to the video website. That is the role, and the same role is played by the principals of the Tejan Institute also. This is the procedure. Whereas in the Allotment, they are alleging that my client has not given the marks to the concerned Gagan Gowda. Gagan Gowda has simply submitted the project, but he has not attended the sometimes. Because of which course teacher has not given the mark, and the project coordinator has also not given the mark. So when the final result and the principal was
No, but
aware,
in the legal notice, your ultimate claim is only for payment of that 6 lakhs.
Your Lordship,
Nothing more than that.
When
See the page 50.
21 ನಲ್ಲಿ September 2021 ನಲ್ಲಿ the client the petitioner
You asked for release of a September, October, November salary. I further state that by unlawfully holding my client so and so, because he is left unemployed till now, once you are able to pay him academic year 2021 salary of rupees 6,16,000. So that is all. You did not ask for reinstatement. You only want this amount.
Having this pay, but we have paid from 2021 to 2022. In spite of sending this legal case.
ಏನ್ ಮಾಡ್ತೀರಾ ಕಂದ್ರಾಜ್ ಅವರೇ?
No, no. Malas, your lordship may turn to malas page 65. Page 65. Malas, explanation given by the malas HOD.
You have not conducted any inquiry
That's
against.
not necessary, malas, not necessary. Malas, I'll explain. Malas, I'll explain. Not necessary. Malas, on their own conduct, malas, he himself abstained from working.
All right.
Page 65, malas, R17, annexure R17.
Yes.
Malas, notice is issued to two persons, Gayatri and malas petitioner. It is noticed that you have awarded less marks than required for a student by name Gagan Gowda, very number so and so, due to which his final marks in the result are published as NE, as the project and internship coordinators,
ಅಂದ್ರೆ ಏನು?
page 65 of the objections.
NE ಅಂದ್ರೆ ಏನು?
NE not eligible anta, not eligible. As the project and internship coordinators, you are liable to give an explanation for the same. Provide the explanation by noon today and met the undersigned and the principal without fail. Well, let's turn to next page, Malas. Page annexure R8.
Please let him finish.
Madam, the student has not given internship and project presentation during internal assessment. Later, he explained that due to internet issues, he could not give presentation. During the second chance, he could not attend, and later he informed that he was not well. Hence, we have decided to give him minimum passing marks. However, we misunderstood that passing is 40 marks and hence awarded the same below 50 marks and above 40 marks. As per VTU rules, internal assessment 50% minimum, and hence the result is showing us NE if permanent. We will reassess the student and award and fresh marks. Malas, he did not read the VTU rules and regulations. He awarded less marks.
So you wanted him to give marks even though the student not attended the exams.
No, Malas, he has attended. He has attended, Malas,
Was his reply. This was
without
his-
understanding the,
This was his reply at page 66, that he did not attend for the second time.
no, Malas,
The
for the
third time he said he was unwell. And yet you wanted him to be given passing marks.
passing marks is 50, but he is awarded 40 marks.
No, no, in essence, you wanted him to give marks even though he had not attended that internal assessment.
Not attended, Malas, he is attended. He is attended, Malas, he has awarded less marks.
What was your response to annexure R8?
Annexure R8,
ಇದಕ್ಕೇನು ಉತ್ತರ ನಿಮ್ದೆ? ನಾವು what happened there afterwards?
annexure R8. Annexure R8 is Malas letter, certificate.
Our reply ಅದು.
Allala.
Annexure R18, sorry, R18 page 66 was his reply. What happened there afterwards?
Malas, thereafter, Malas, he started quarreling with the Malas HOD and principal. Malas, this is 26/8. From Malas 15/9/2021, Malas, he applied for leave. Malas, examination work was going on. Malas, without attending the examination work, he applied for leave. Your lordship may turn to Malas.
What did you do? What did you do?
Malas, we need not have to do anything, Malas, because he himself has abstained from 15/9/2021. 7 days he applied. Malas, thereafter, Malas, complete.
Where is your notice saying that you are not coming to the college? If you don't attend the college, you will take action against you. Where is the notice?
Malas, we have not issued any such letters, Malas. We have informed orally, Malas, over phone. We have not issued any letters. Malas, from 1/10/2021, Malas, he did not attend the college work. Malas, there are absolutely no record produced before this honorable court to show that, Malas, we have abstained from.
He has given this email to you. Did you respond
Malas,
to this email?
Malas, except Malas emails, Malas, there are no records. There are no records.
What do you require, Mr. Kantaraj?
Malas, your lordship may turn to Malas page 39.
Page 40.
Page
was his-
39, Malas, your lordship.
Page 40 was his email.
Yes.
You have not responded to any of his emails.
No, we have informed them, Malas, we have informed him over the phone, Malas. We have not responded to the
What did you
emails.
inform him over the phone?
Malas, only Malas, principal has informed him. Malas,
What?
this is not the
What?
way, this is not the way. You please come and, Malas, attend the work. Your lordship may turn to page 39, Malas. 39 of the writ petition.
There is no document
Malas,
asking.
he himself, Malas, he is not interested in working. He himself sought for Malas experience certificate and Malas original marks card. Your lordship may turn to page 39. 39, Malas.
Did you give a reply to the legal notice?
No, not Malas, not.
Sir.
Malas, kindly arrange to issue my experience certificate and original master certificate for my future livelihood planning. Kindly inform the date on which I can come and collect. In case you are not willing to allow me inside the campus, send the same as early as possible through a registered post to the following address also. I prefer to come under zones. We have prepared. In fact, earlier writ petition, he himself has filed writ petition. Earlier writ petition, I have produced the copy of the order passed by this honorable court. 14/571 of 2022. Your Lordship, turn to Annexure R1, page 12. Page 12.
I have a.
Madam, you should keep quiet when you start arguing.
Para 4, the prayer of the petition for a direction to the respondents to pay compensation of rupees 10 lakhs for the harassment and lost livelihood that the petitioner is suffering from October 2021. Whether the petitioner is prevented from attending the college or as to whether the petitioner has abandoned the service, whether the petitioner is denied to work or in lieu of salary, whether the petitioner would be entitled to compensation, are all matters of evidence, and the court under Article 226 of the Constitution of India would not be in a position to assess the compensation or damages. Moreover, if the petitioner is denied work by the respondent's institution, the petitioner has to approach appropriate forum. No writ petition with the above prayer would be maintainable. I decline to entertain the writ petition with in exercising of discretionary jurisdiction Article 226 of the Constitution. Accordingly, petition is rejected.
Yes.
Before rejection, this honorable court has directed me to provide the original mass card. Your Lordship may turn to Annexure R19. Annexure R19. Along with memo, I have placed the original mass card before this honorable court. Pursuant to the directions of the honorable court, the respondents furnished the original master degree certificate so provided following formalities are to be completed. He did not refuse to receive the original master degree certificate. Therefore, this honorable court has passed an order.
Reinstated.
No, that can't be because the department itself is not working because it is closed.
You can pay him the salary then.
But that can't be that can't be because our your Lordship may turn to Annexure R20. R20. Annexure R20.
You are gone by statutory regulations.
We have taken a decision. It's our policy that retirement age is 58 years.
It's not for you, sir. It's a statutory regulation.
Statutory that has not been brought into force. We are not college because it's a private college. It's a private educational institute.
You are a technical education. Yes. You are granted affiliation by the authorities. Yes. You are bound to comply with that regulations.
That has not been complied with. Yet to comply. That will take decision in the future course. Not a taken decision.
Engineering college we will decide what we will apply and what we will not apply. You want me to record that?
That has not been taken decision so far.
How can you say that? Your affiliation will go. You say that I will decide.
That is not the prayer made in the writ petition. That is not the prayer made in the writ petition.
I will record what you said here and make that observation. You want that?
All that petitioner himself has abstained, and the legal notice, your Lordship turn to legal notice produced by them. Your Lordship turn to legal notice. They themselves have produced. What is their request is to be granted. Without which this honorable court cannot go beyond that. Your Lordship turn to page.
What this court can do or cannot do, don't worry.
I'm not. Page 45. 45. Para. Page 50. Due to all the facts mentioned above, I say that by removing my client without prior notice and without reasons for you, there is absolutely no removal question does not arise because he himself has abstained. Third of you and fourth of you have exhibited most unprofessional conduct towards him. Further, you have subjected him humiliation and mental harassment, blocking him in the entrance of college by security. And hence, I call upon you to immediately release his September, October 2021, so on, so on. That means, petitioner was aware that his retirement age is 58 years. He is retiring on 27/12/2021. He anticipated that he has been dismissed. He sought for
27/12/2021 ಸಂಬಳ ಅವ್ರದೆಲ್ಲ ಕಾರ್ಡ್ಸ್ ಡಿಜಿಟಲ್ ವಾಪಸ್ ಕೊಟ್ರೆ ನಾನು ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ಅಂದ್ರೆ I will apply the regulations and say that
no, 3 months. I myself voluntary.
Not 3 months. till December 2021 and give him back all the documents that he has given to you. I'll
Yes.
close the proceedings here, or else I will
That we will
direct
pay, my lord. That we will pay, my lord. Till
Okay,
December
when-
2021, must I,
will you pay?
I'm gonna send, that I'll have to inquire with my institution.
Tomorrow.
Please, no.
Take salary till December 2021 and I'll ask him to give back all your certificates.
I have asked for one compensation for all.
That, madam, you lost already.
All that cannot be granted.
That you already lost by the dismissal of the early rate petition. You should have filed an appeal against that order.
We ಮಾಡಿದ್ವಿ your lordship.
ಅದು ಹೋಯ್ತಾ? ಮತ್ತೆ ಅಷ್ಟೇ ಹಂಗಾರೆ. December 2021. You'll get salary till December 2021.
ನಾನು ಈ prayer ಮಾಡಿದ್ದಕ್ಕೆ ಒಂದು reason ಇದೆ your lordship. You know, I humbly pray.
Madam, nowhere in your legal notice or in your complaints, you sought for reinstatement. You virtually said, I'm prepared to get out of your college, give me everything that I am entitled to.
Without it, so ನಮಗೆ ಏನು ದಾಖಲೆ ಇರ್ತಲ್ಲ.
ಅದಕ್ಕೆ ನೀವು ಅದು ಯೋಚನೆ, ಆ ನೋಟಿಸ್ ಕೊಡೋಕ್ಕಿಂತ ಮುಂಚೆ, ಆ ಕ್ಲೇಮ್ ಮಾಡೋಕ್ಕಿಂತ ಮುಂಚೆ ಯೋಚನೆ ಮಾಡ್ಬೇಕಿದ್ ನೀವು. I can get you that salary till December 2021 and ask them to return the certificates.
This is not the case of one lecturer. I wanted,
Not a PIL. Don't convert this into a PIL.
now, even this photo, you ಹೇಳ್ತಾ ಇದಾರಲ್ಲ, your lordship, ನಾನು ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದ್ದೆ, ಆಮೇಲೆ ಎಲ್ಲಾದ್ರೂ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಎಲ್ಲ ತಂದಿದ್ದೆ, ನೀವು ಅದೇ ಮೆಮೋನ ನೋಡಿದ್ರೆ, please come to page 67, your lordship. What they said is, we have to submit all these documents. then
You don't worry about all that. Whatever documents that you had given them, they'll give it back to you and pay you that amount till December 2021. If they don't, they know the consequences.
Your lordship, I accept that, but I also humbly submit that they should be penalized for whatever they have done.
First ನಾಳೆ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ ರೀ, ನಾಳೆ ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ.
But only thing is, well, when we will have to pay, well, so that I'll consult it and.
Everything should be ready, package deal. If you say this way or that way, they will suffer a consequence.
Well, tomorrow, well, half day. Well, instead of tomorrow, day after tomorrow.
Before 1:30, you can come and mention.
Please.
Tomorrow.
Additional some amount has to be paid.
Madam,
Because he has lost so much of.
You lost your writ petition and the writ appeal. If I do anything now, I'll be going beyond the order passing the writ petition. I also have my limitations. Whatever is possible in this petition, I'll do. If they don't agree for this, there is a consequence that they'll pay, which will be much more serious. So let them apply their mind and then see.
ನಮಗೆ ಈ ನಮ್ಮ ರಿಪಿಟೇಷನ್ ಅಲ್ಲಿ ನಾವು ಹಿಂದೆ ಹಾಕಿದಾಗ ಅದರೊಳಗೆ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ. We have to go to the appropriate forum ಅಂತ. But unfortunately, the honorable judge didn't see that. We don't have any documents to go to anywhere. ಅದನ್ನ ಅವರು
That's why I said, madam, I can't go beyond that order. And that is also confirmed with division bench.
the order was very blunt.
Next, Supreme Court.
Without seeing
You
any
should have,
evidences which we have produced.
ನಾಳೆ ನೋಡಿ ಯೋಚನೆ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ reinstatement
No, well,
till he attains the age of 65
no,
years.
well, we will pay for 3 months salary. Well, there's no doubt about it. Well, only thing is, well, when they will pay, well, I'll just inquire it and.
ಬೆನ್ಗಿನ್ನಲ್ಲ, ಎಲ್ಲ ರೆಡಿ ಮಾಡಿ ತಗೊಂಡ್ ಬಂದ್ರೆ ಆಗುತ್ತೆ. ತಿರ್ಗಾ ಬೆನ್
ಎಲ್ಲ ರೆಡಿ ಮಾಡಿ ತಗೊಂಡ್ಬರ್ಬೇಕು ಅಂದ್ರೆ ನಾಳೆಗೆ ಆಗೋದಿಲ್ಲ because
ನಾಳೆ ನೀವು ಹೇಳಿ ಆಗುತ್ತೋ ಆಗಲ್ವೋ ಅಂತ. ಇಲ್ಲ ಅಂದ್ರೆ
that we will say make submissions.
ಹೌದಾ? Yes, Vikram.
In this case, I've prepared one note for your lordship's benefit. Just labeled it as a note, because I've not said anything more. It's quite exhaustive. I'll just take my lords through the relevant portion of it. Lord, may kindly see up to paragraph 6, paragraph 7, really, my lords, is the facts of the case. and an analysis of the provision of the Local Act. I think your lordships has already exhaustively dealt with it in the other matter, where the 12.3 report your lordships had quashed sitting in Harvard. Now, para 7, my lord, although it's elaborate, I'll just paraphrase it. The rule really is, my lord, whether there is any apprehension, whether any real apprehension of bias, and who should perceive that bias, and any reasonable person should apprehend that there is any bias. Now, I understand, what I understand, your lordship's concern here is under regulation 14A. Upon receipt of a report, the board may send it back to the very person who has sent the report. Now, frankly, it would, any reasonable person would perceive an element of bias. I don't think there is two ways of looking at it. There is certainly an element of bias that a person would perceive if the report were to be sent back. Of course, paragraph 7, 7.3 and all deal with what the standards are for bias. 7.3, 7.4 also. Then if I also to turn over the page number 10, numbering is at the bottom. Yes. I've also added some judgments to show how the courts, so the Supreme Court has made a distinction between bias insofar as a certain factual scenario is concerned, and also bias insofar as certain policy matters or any legal bias. So there the Supreme Court has said that there's no question of ascribing any policy bias. Now, in one judgment, for example, the minister who was supposed to decide on a matter of nationalization had openly spoken in favor of nationalization. Subsequently, the grievance was raised saying that he's already spoken in public, he can't hear the matter. There, the Honorable Supreme Court said there's no question of policy bias. If in the given facts of a case, any opinion has been formed, then certainly there would be, that's what is covered by the principles of natural justice, but there's no question of policy bias. In fact, there's one interesting judgment of the Honorable Supreme Court where bias was alleged against a judge of the Honorable Calcutta High Court. Without going into the facts, only the standards. There, in fact, the Honorable Judge had sat in, initially passed an order, that order was set aside, then subsequently a division bench, he sat and once again passed the same order that he had passed sitting as a single judge. The Honorable Supreme Court set aside the order, but if my lords were to see para 25, this is again the legal standard, para 25 at page 524. So bias may be defined as a preconceived opinion or a predisposition or predetermination to decide a case or an issue in a particular manner, so much so that the predisposition does not leave the mind open to conviction. It is in fact a condition of mind which sways the judgment and renders the judge unable to exercise impartiality in a particular case. Bias has many forms. It may be pecuniary, personal bias as to subject matter in dispute, or policy bias, etc. In the instant case, we are not concerned with any of these forms of bias. We have to deal as we shall presently see, a new form of bias, namely bias on account of judicial obstinacy. Then paragraph 29, I'll read one. So the same judge sat in appeal subsequently and reaffirmed his own order. Anyway, as pointed out earlier, an essential requirement of judicial adjudication is that the judge is impartial and neutral and is in a position to apply his mind objectively to the facts of the case put up before him. If he is predisposed or suffers from prejudices or a biased mind, he disqualifies himself from acting as a judge. But Justice Frank of the United States and so said, if however bias and partiality be defined to mean the total absence of preconceptions in the mind of the judge, then no one has ever had a fair trial and no one will. The human mind, even at infancy, is no blank piece of paper. We are born with predispositions. Much harm is done by the myth that merely by taking the oath of office as a judge, a man ceases to be human and strips himself of all predilections, becomes a passionless thinking machine. These remarks imply a distinction between prejudging of facts specifically relating to a party as against preconceptions or predispositions about general questions of law, policy, or discretion. The implication is that though in the former case, a judge would not disqualify himself, in the latter case, he may not. But this question does not. So only to distinguish between a predisposition on facts of a given case and predisposition insofar as law is concerned. Then paragraphs 35, 36, I won't read, Malus, where the order was set aside. So this is the legal standard, Malus, insofar as bias. Now, the next question I asked myself, Malus, was generally speaking, orders which suffer from any bias are administrative or quasi-judicial orders which are subsequent, or sometimes also judicial orders which are subsequently challenged. That is qua the order itself. Now, here, my lords, there is a regulation which prescribes the manner in which the board can send it back to the same person, whether it's the Lokayukta or the Upalokayukta, who formed an opinion and submitted a report. So the question I asked myself was, would the provision itself be prone to challenge? So can a provision be struck down on the ground that it gives rise to potential bias? Now that is answered, my lords, in a subsequent, in a judgment of the Honorable Supreme Court in Bidhan Nagar, where in fact, not just a delegated legislation, but a plenary legislation itself was struck down. There, what happened was, I won't take my lords through the entire facts. There was a committee that had to decide on a particular fee. That was done by an assessing officer, and the fee valuation had to be reviewed by a higher authority. Now, the provision set out the manner in which the review authority is to be constituted. What the Honorable Supreme Court found was that the persons who formed the original opinion regarding the valuation formed part of the committee. And the Honorable Supreme Court struck down the provision on the ground that this gives rise to institutional bias. So the authority itself, there may be one or two persons who may be completely free from all bias. But even if there are one or two persons who form a part of the review committee, the institution, the committee in this case, could be held to be biased. Now, my lords will find the relevant observations at paragraph 26 and 27. Page 685. The provisions, in our opinion, are per se unreasonable and arbitrary. The review committee is not independent of the municipality or the board, whereas under the 1978 Act, a person having the requisite knowledge was to be appointed by the state government as chairman of the review committee. The affairs of the review committee are controlled only by the municipality concerned and the board under the Amendment Act. The Amendment Act was under challenge. The municipality essentially is interested in increase in valuation of lands and buildings, as it would fetch more income to its coffers. It is unthinkable that although the power to make annual valuation is not to be preceded by an opportunity of being heard to the person who would be affected thereby, the power of the review committee has been curtailed to 25% of the valuation made by the board. The members are not independent persons, and each one of them is in one way or the other interested in the matter. Even the officer nominated by the board, who is said to be an expert, might have something to do with the annual valuation of the area in question. In any event, the effect of the amendment is that annual valuation is to be made by the board. Then the objections are to be heard by a committee, which again consists of members of the municipality and the board. And in the event the decision is not unanimous, the matter again goes back to the board. This provision is akin to the well-known doctrine of Caesar to Caesar. It per se contravenes the values attached to the principles of natural justice. We must also take notice of the fact that even the jurisdiction of the civil court is barred and only remedy that may not be relevant. So this is only to point out that a provision, even a plenary legislation, which gives rise to potential bias is liable to be struck down. So it's not just the order per se. Now, in the matter your lordships passed sitting in Dharwad, the 12-3 recommendation was squashed by your lordships. Now, the question here is whether the regulation that permits any potential bias, whether that can also be struck down. And the answer is very clearly yes. In fact, delegated legislation, there are well-known parameters on which this honorable court under Article 226 can strike it down. One of them is on the ground that it violates principle of natural justice or violates any constitutional provision. Now, your lordships knows natural justice imbibes the rule against bias. Natural justice is imbibed in Article 40. So therefore, that way your lordships can always find that a provision or a delegated legislation violates the principle of natural justice, thereby offends Article 14 and can be struck down. So this is the law, my lord. Now the question really is in this case, whether Regulation 14A is liable to be struck down or not. Initially, I was of the opinion that it possibly is liable to be struck down. It ought to be struck down. But one way, I was just a suggestion, one way of possibly saving it. Now, there's a recent judgment of the Honorable Supreme Court, 2023. Here, what had happened is the Orissa Lokayukta had the power to refer a matter for inquiry to any agency. A complaint in this case was filed by an officer of the Vigilance Directorate. The complaint was taken on record by the Lokayukta and sent back to the Vigilance Directorate for inquiry. So one of the grounds raised was that since the complainant is the Vigilance Directorate. You cannot send it back to the Vigilance Directorate for further inquiry because there is that would offend the rule of bias. But what the Honorable Supreme Court found was that the complainant was the the complainant, my lords, was the Deputy Superintendent Director of Vigilance, while the matter was sent back to another superior authority or any other authority. So therefore, that would not offend the rule of bias. My lords will find those observations at page, paragraph 34. So far as the objection raised by the respondents regarding the action of conducting preliminary inquiry being biased for the reason that the Deputy Superintendent of Police of the Directorate of Vigilance has submitted a complaint, and the appellant directed the Directorate of Vigilance to conduct a preliminary inquiry by an order dated 11th December 2020, which in fact was conducted by a senior officer of the Directorate of Vigilance, that is Additional Superintendent of Police, Mr. So-and-so, who submitted a report to the appellant on 28th May 2021 is concerned. We are not persuaded with the submission of there being any bias on the part of the Directorate of Vigilance cell in conducting a preliminary inquiry for the reason that the officer who submitted a complaint was simply an informant and not the person interested at the same time. Preliminary inquiry was conducted by a different officer, not connected with the author of the complaint. Thus, the plea of bias was ill-founded. In our view, the principles of bias, even remotely, are not attracted in the facts and circumstances of the present case. Now, although not exactly the facts in this case, why I thought I should bring to your lordship's attention this judgment is the Lokayukta as an institution itself, my lords, it might, in my respectful submission, be maybe a step too far to say that the institution itself would be tainted with bias if either the Lokayukta or the Upalokayukta were to make a report upon which the matter is sent back to inquiry. Possibly one way of saving the virus of this regulation, and similar provision KCSR is to ensure that it does not go back to the same officer. For example, the Lokayukta makes a report or the Upalokayukta makes a report. Possibly your lordships can read in a safeguard to say that it should not, when the inquiry is entrusted back, it should go to the other person. So if
But then,
it's just a suggestion.
Retired High Court judge's recommendation.
No, I see the practical aspect. Now, I even examine the question as to whether the Lokayukta is in any way superior and the Upalokayukta is in any way subordinate to the Lokayukta, in which case, then certainly a Lokayukta's report cannot be sent to the Upalokayukta. But I didn't find any provision in the Lokayukta Act which makes them in any way administratively or otherwise or quasi-judicially subordinate to or superior to each other. One way of saving the provision, that's just a suggestion. Because here also, what the Honorable Supreme Court said is that the Directorate of Vigilance itself cannot be, as a whole cannot be...
so long as the inquiry officer is under the administrative control of the Upalokayukta, Lokayukta, the probability of that gentleman saying that the recommendation was wrong or that inquiry is
unlikely. Yes, absolutely. I'm just a suggestion.
If there's an independent body not under the control of that institution.
Yes,
maybe that can be a way out for.
That's right.
Because I understand the concept that the government does want to have control in cases where the investigation is done by the Lokayukta. If it does an investigation, there must be some material in it. If he has to make a recommendation. But that recommendation to hold an inquiry should be conducted by somebody who is independent of.
Absolutely. No, so one of the ways of, since the report is made in the name of the Upalokayukta, could it not be said that the regulation has to be read in such a manner that if it has to be sent back and under regulation 14A, it's a major penalty is contemplated, could it not be sent to the Lokayukta? Because there are two retired High Court judges independently functioning in their own individual capacities. That's, like I said, it's just a suggestion. I was only thinking of ways of saving the provision also. Since I was assisting the court, the simplistic way of looking at it is that there's certainly an element of bias. Now, if I make a report and it's entrusted back to me, it would be difficult to say that a reasonable person would not apprehend bias. And the parameters of this is to see whether a reasonable person would apprehend bias. And it's not real bias, because real bias can never be proved, because it's a notional aspect in somebody's mind, which is why the test has always been whether a reasonable person would apprehend, whether there's a real likelihood of bias. And I would think, Manoj, there would be. First answer would, yes, there certainly would be. Any layman would think that.
On an average, how many inquiries are conducted by the Upalokayukta? On average.
We are in the process of preparing that data. The data I'll place on record the numbers in relation to how many 12-3 reports we have said, please conduct preliminary inquiry, please conduct departmental inquiry. And in the department inquiry, it is not proved.
No, that's all right. So how many inquiries?
How many inquiries?
How many inquiries are recommended by you on an average every year?
Not that has over last 5 years, it has substantially, the numbers are different. I'll place that also, Madam. It could be in not 3,000, 2,000, 1,500, it could be like that. It has been not the last 2-3 years. I can place it on record. It has been on a decline.
Panel of retired High Court judges
For what?
to conduct the inquiry instead of a district judge.
But right now, under section 15(1) and 15(2), retired district judges are appointed there.
Equivalent.
Your lordships are suggesting. It is under the scheme of the act. As an officer of court, your lordship thinking could be right. But under the scheme of the act.
Legislation would have to be, I'm not sure.
My only concern is about.
And it's a well-founded.
That data I'll place, the relevant question my lord has, we are working on that data. That the number of 12-3 reports where we have said the disciplinary inquiry is required and which have not sent back to us, we have conducted inquiry and where the person is exonerated. In the inquiry, it is found not true. So 12-3 report inquiry not true, there are quite a few number of cases. So that also, that numbers I'll place before me.
That's a dangerous field.
No, because then again,
Because materials are different. 12-3 gain material disciplinary inquiry
Any other independent authority?
No, as the lordship suggested, possibly if a
I don't know, 10, 20 retired High Court judges, if they can handle it, that will be a better option instead of asking retired district judges to do it.
But we are not asking retired district judges. The retired district judges and serving district judges, both are there.
An observation by us in our order leads to so many consequences in the trial court.
Yes,
So I'm not very keen on somebody who can independently assess without being influenced by the full of this recommendation is what I'm looking at. If you can have a panel of retired High Court judges, that's one thing. But so long as they're under your administrative control.
Whether we can have a panel of retired High Court. Should I take it?
If it comes from you, it will be easy for me to record and then save the rule on the basis of your statement, or else.
But I'll take it.
That way, at least this fear that the district judge can't go against a High Court judge will remain.
I'll take instruction.
On that aspect.
Anyway, there is one pool of 25 inquiry officers. Your lordships are suggesting that there could be another pool of another 10 retired High Court judges. And, yes,
They'll just be like arbitrators.
Yes,
be like arbitrators, but
they will hold the inquiry and take a decision one way or the other.
I got it.
Then at least that delinquent will have that feeling that
correct.
It was done in a fair manner.
But even but I can.
No, that it's a question of a frame of mind, isn't it?
That's all. It's a frame of mind. That's the.
And then your lordships are also saying the entire inquiry wing has to be abolished.
That's up to you. Whether you want to abolish it or not, it's up to you.
Restrict themselves only to this aspect, my lords, if at all, if that is so that they don't go into the domain of the others also, my lords.
Independent agidre ondakondake without any link to one another, please, I'm okay.
I'll put it to Lord, I'll take instruction.
If that is there, I have no problem. I'll record your statement and hold that the inquiry will be done by a panel of retired High Court judges, and on the basis of which Rule 14A will operate, but not for somebody under your administrative control. That could be a via media way of until they decide to frame the rule, change the rule or whatever. Prima facie, I think that will be the better way out.
I'll take instruction.
The whole object is to remove any potential for even not real bias, but perceived bias.
To that extent, if the institution agrees, the problem can be solved. Because this I'm telling you because of the fact that you're filing writ petitions. challenging the punishment that is not imposed according to your desire. That according to me is proof of your inherent bias, that you're not
Choice of
satisfied.
words, not. Your lordships are saying according to your, we can demonstrate from each and every case.
No, that is what happens if you are prosecuting him on the criminal side, you are prosecuting him on the department side. After the punishment also, you are not satisfied.
And that,
So even if he's
Could be.
acquitted there, he will definitely suffer here.
but not satisfied in the sense, Lord, if not the order is passed, which is not in accordance with law, only
But,
that will bring
Dekhe,
into-
you don't be the judge of your own cause. Let somebody else be the
Absolutely,
judge.
but we are not playing that role at all. It cannot be. We are bringing it at your lordship's doorsteps. Your lordships are going to decide finally. What
But
happens.
you coming to the court by itself indicates an interest in the matter. It's like me filing a writ appeal against,
I have an interest in the matter. But the objections, statements of objection.
no, it's like me filing an SLP against the order of the division bench, saying that that order was not correct. Atra ಆಗ್ಬಿಡ್ತಿದೆ
I do
actually.
not play that, not a judicial. Yeah, on a lighter note. your lordship.
Like this, on a lighter note, like the Supreme Court, bias of obstinacy or something.
Judicial of-
Judicial obstinacy.
ಅದ್ ಕೇಳ್ಕೊಂಬನಿ, that is, if you agree for that, to my mind, whatever apprehension I have is solved.
No?
Whatever apprehension I have will be solved if you agree for that
If
panel of
not, I'll
retired High
take
Court
it.
judges. It's coming from you, it will be easier for me to record that and close the proceedings.
Yes.
ಯಾವತ್ಗ್ ಹಾಕೊಳ್ಳಿ?
Not tomorrow and not day after tomorrow. Friday, Lord. Or
Friday.
Monday, whichever day.
Friday.
Obliged.
Thanks.
Obliged.
Great.
ಏನಾಯ್ತು?
Let's, on the last, my lords have heard the matter.
Salary.
Salary, break-in service to issue was there. My lords, before vacation, when this matter, my lords, was treated as part heard. My lords, we had argued our petition for the vacating stay, and thereafter my lords had heard and asked us to file our affidavits, and they had filed counter affidavits. Now, my lords, there was one tabulated statement we had given, where there was a break-in service, my lords, for a period of 5 years. And before that, how many were employed? Some were employed, some were not employed. That entire statistics is on record. Now, my lords had referred to the LIC judgment and said to give a quietus to this, whether explore if we can close this issue, because there is break-in service any which way, and whether this matter could be closed, because the printing press is closed, my lords. We don't have any work there. 50,000 in LIC judgment, the Supreme Court, my lords, in that matter, fixed it at 50,000 rupees for every year of service that they have rendered. Then, my lords, we cannot straight away concede to any position, my lords, but to also see if there was any contra position with regard to, on the basis of which some benefits could be calculated. Lords, under the Daily Wages Welfare Act, initially, my lords, we had fixed a ex gratia that was given to them on the basis of 15 days pay for every completed year of service. Then, my lords, we have brought in an amendment which says now that they are entitled to gratuity in terms of the Payment of Gratuity Act, the central legislation itself. Now, my lords, that could be one guidance, because though the Daily Wages Act will not apply here because they do not come under that, but there are two. One is the LIC judgment that could be followed. But for LIC judgment, my lords, my submission would be that after the break-in service, they have rendered continuous 8 years of service. Before that, there was 5 years break-in service. So if we take the previous years of service, my lords, that 50,000 per year might be a slightly onerous thing for the state. But if we calculate under the Payment of Gratuity Act, my lords, even if they had rendered any service prior to that break-in service of 5 years also, that could also be taken into consideration, because it will, the total amount might come to the same thing, but there is some statutory guidance for this purpose is what we are rendering, because that was in the context of one in the LIC case that Supreme Court had rendered as to give quietus, my lords. That could be maybe a specific direction for the facts of the case. There was no precedent value for that. Insofar as 50,000 was concerned.
But under the 2012 Act, they are continued as daily wages till they attain the age of superannuation. Here you are cutting them off right now.
50 under the Daily Wages Act, ex gratia is only at the superannuation.
So that they get employment till the age of 60. Here you are not doing that.
We are not giving. Here there is no work, so we wanted. That's what, my lords, to discontinue them. My lords had put across to us that see if something could be done in terms of what was done in LIC. I will leave it to the court, my lords, because as a matter of
how many years of service have they rendered?
My lords, 8 continuous years of service before the break in service, my lords, of 5 years.
But together 13 years.
ಅಲ್ಲ ಅದರಲ್ಲಿ 5 years ತಗೊಳಕ್ ಬರಲ್ಲ, 5 years ಕೆಲಸ ಮಾಡಿಲ್ಲ. Before the 5 years break in 2010 to 15 there was break in service. Nobody has worked
For that, before that.
before that, my lords, from 2000 to 2015 for a period of 10 years, some have worked, my lords. Some have, in the sense, initially around a few of them, 5 of them would have worked from 2010 itself. ಆಮೇಲೆ ಕೆಲವರು ಜಾಯ್ನ್ ಆಗ್ತಾ ಹೋದ್ರು. So in the 10 years of service, some person might get full 10 years, another person might get 8 years, or another person might get 7 years, in that range. Then we added, my lords, to 2016 in the 10 to 15 minutes admitted position that they have not worked anywhere. That also they have considered to that fact. So, my lords, under the Payment of Gratuity Act, my lords, if the entire amount, the full service, including the service that was rendered prior to 2010 also could be taken into consideration. My lords, not as a concession, my lords, subject to as an order of the court. My lords, it provides for a specific formula also, and also that act also provides, if my lords may kindly see section 4, my lords, of the Payment of Gratuity Act.
Altogether, how many years of service do they have maximum? Including prior to the break?
Please, my lords, I'll give that. Maximum might come to around 18 years.
So that is at 50,000 rupees, almost 10 lakhs.
Also, ಅದಕ್ಕೆ 50 ಏನಾದ್ರು ಮಾಡಿದ್ರೆ, from 2015 onwards, that 8 years, my lords.
For an 18-year-old, for service of 18 years.
ಇಲ್ಲ, ಅವ್ರು ಮಧ್ಯದಲ್ಲಿ 5 years ಬೇರೆ ಕಡೆ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ, and then this is a peculiar case, my lords, where they never worked with us for 5 years. There was no then thereafter, my lords, once the factory started in this place, they came back, and then now it is closed now. I just pass on.
How old are the petitioners?
Lords, petitioners,
If they put in 18 years, they must be close to 50, on the verge of retirement.
ಇಲ್ಲ ಸುಮ್ಮನೆ, I will.
Definitely in the region of 50s, isn't it?
ಇಲ್ಲ, first petition, some are in 50s, my lords, rest are in 40s, my lords. Section 4, my lords, have, my lords. Section 4 ಅಲ್ಲಿ 4(2), my lords, my candies.
Same, this is the principle borrowed in your 2012 Act also.
ಇಲ್ಲ, 2012 Act ಅಲ್ಲಿ first we just said ex gratia of 15 days for every completed year of service. Then we amended it to say, because ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಬರುತ್ತೆ. That formula is 15 into divided by 29, subject to a maximum of 20
But like
lakhs.
I told you that in that case, they work till they attain the age of superannuation.
No,
Here,
lords, I'm not saying that Daily Wages Act ಕೆಳಗಡೆ, I'm not drawing parity in any which way. I'm just trying to show, lords, that one way of going about a calculation, lords, and another way of going about a
how
calculation.
many people are involved here?
Lords, 32. Petitioners, lords, in fact, are originally they had approached 32 ಬಂದಿರು, ಇದರಲ್ಲಿ 27 ಇದ್ದಾರೆ. But in fact, on the basis of the earlier endorsement that we had issued, salary was paid, my lords, I'm told, to all the 32 of them. So
Be that 50,000 per annum is a better option.
ಅಲ್ಲ,
Please get some sizable amount for them to do something.
lords, that could be capped at 8 years, my lords, because 8 years of continuous service is the 8 years ಅಷ್ಟೇ. My only request, my lords, is if 50,000 based on the Supreme Court judgment, my lords have to cap it at 8 years, because continuous service is only 8 years. Before that, there is a 5-year break, admitted break.
ಅದಕ್ಕೆ ಅರ್ಧ ಆದ್ರೂ ಕೊಡಿ, ಏನಾದ್ರು something like that.
That is where this formula comes, because if I take, lords, there are 2 ways. If 50,000 ಕೊಟ್ಟು 8 ವರ್ಷ ಮಾಡ್ಬೋದು ಒಂದು, ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ full entire ತಗೊಳ್ಳಿ, including the previous years, 18 ವರ್ಷ ತಗೊಳ್ಳಿ, ಈ ಫಾರ್ಮುಲಾ ಹಾಕಿ ಅಂತ I'm just trying to.
But on the rate of wages last drawn ಅಂದ್ರೆ ತುಂಬಾ ಕಮ್ಮಿ ಆಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ, last one plus DA ಕೊಡ್ತಾರೆ. ಈಗ it is wages.
Just give me the difference as to what is the difference at 50,000 per annum and at.
Please, minutes.
Let us see the difference, whether it is substantial or more or less close.
Please. I will build 50,000 for 4 years, 8 years, and this calculation, my lords, for the entire 18 years.
Okay, give for both. Let us see what is the.
I will give even 50,000 for the entire 18 years.
Eventually, I will.
It's Monday. What is a book?
For the respondent, my lord.
Yes, Puna.
The last occasion, my lord wanted to know what is the action taken by the executive engineer, my lord, and wanted the executive engineer to be present along with the records and an assessment to be made if any amount in terms of compensation can be paid. The executive engineer is here with the records, my lord. I also went through the records. My lord, the position is in the year 1998, there was no standing trees at all, my lord, in the land of the petitioner. Now, the present owner is the petitioner. During the relevant point of time, there were no trees at all. Only if the trees are there, notice will be issued, sketch will be drawn, mahazar will be drawn, and will issue a notice to remove all the standing trees and compensation will be assessed and granted. Since there were no standing trees at all in the land, no notice was issued and no compensation also was paid.
Which rule says that if there is no trees, you can proceed to erect the other towers without notifying the owner,
My
or
lord,
without assessing the damage?
That time, my lord, we have the records, Hinde landu, Munde landu, for everything we have assessed, how many trees were there, notice was issued, what is the amount granted,
The-
but
the
that time, my
Trees is
lord,
one separate component in itself. But what, suppose in a given case where there are no trees, you pay no compensation at all?
no compensation at all, my lord. At that point of time, of course, now in the present time, for the utilization of the land also, for corridor, we are paying. If we erect towers, we are paying. That is only after 2015, my lord. But during that time, we were not paying, only for standing trees. My lord, during
Let's see the act,
1980s.
Telegraph Act. Does the act provide for such kind of
Yes, my lord. that
zero
is-
compensation?
Yes, my lord. Was only the act itself is 2003 and subsequently only.
Earlier was a Telegraph Act, isn't it? You were laying lanes under the Telegraph Act.
Telegraph Act only, my lord, but no compensation was paid for corridor, for towers.
Which is a provision which provides for compensation under Telegraph Act 16, not 10.
In the year 2015, my lord, a notification was issued by the Ministry of Power, my lord. From that time onwards, I have the notification for damages caused.
No, how can you say by erecting a tower, there is no damage at all to the property?
My lord,
Placing the land belongs to the petitioner. And they can't say that we are not using it. I'm sorry, I cannot grow any crop at all with the land.
it is not
It's a
so, my
very
lord.
strange argument before this.
No. My only submission is during 1998, compensation was given if we had cut any trees, my lord.
Now, where do you get that? On what basis are you saying
My
that?
lord, that was the procedure followed, my lord, until 2015.
What is the law? Not the procedure. What is the law that
Law also says so, my
you
lord.
lay the electric poles on under the powers of the Telegraph Act?
Yes, my lord.
Telegraph Act says, in the excess of the powers conferred by this section, the Telegraph Authority shall do as little damage as possible, and when it has exercised those powers in respect to any property other than that referred to in clause C, shall pay full compensation to all persons interested for any damage sustained by them by reason of the excess of those parts.
Yes,
Don't you think the damages caused to them when you take away a portion of the property and erect a tower?
yes, my lord, definitely damages are caused, definitely, my lord, but during 1998, only if you had cut trees, we would pay compensation.
That is wrong.
That
ma'am.
is,
This is from 1885, this is the law.
no, my lord, that was not followed, my lord. Only after 2013 only, we are paying for every.
ಎಷ್ಟು ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ನಿಮ್ ಟವರ್ಸ್ಗೆ?
Land.
ಎಷ್ಟು ಜಾಗ ಈಗ ಹೋಗಿದೆ? ಎಷ್ಟು ಜಾಗ ಹೋಗಿದೆ? Now, do you know the extent of land that is gone? And what is the damage that is given to the others? Damages? What are the restrictions for laying? You can't grow any crop under the.
Under the lines, no, my lord. That was only year 2007.
What is the extent of land that you have lost then? Does he have any idea as to what is the extent of land that is used?
Engineer. Totally, my lord, for tower base width and the corridor, it is 1.318 acres, my lord. 52.72 guntas of land has been used.
So for the pole and the lines across 1 acre
Yes.
is utilized completely.
Yes.
So 1 acre,
The
they can't,
Amongst 3 acres of land which belongs to the petitioner,
so 1/3 of his land is lost.
1.318 acres has been used, which is 52.72 guntas. This much we have used.
What was the guidance value then for
Guidance.
that?
My lord, compensation which we have paid to others is here. I can provide the file. Only for crops.
How much did you pay in your sale deed? What's the sale consideration? You purchased in 2000 alva? And 97 agreement ಎಷ್ಟಕ್ಕೆ ಇದ್ದಿದ್ದು? Other lands ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
Not for lands, my lord, only for the crops we have paid. It depends, my lord, we have paid 3,000, 5,000, 7,000, 10,000, like that. Depending upon the damage cost and the trees removed.
Land ಯಾರು ಕೊಟ್ಟಿಲ್ವಾ ನೀವು?
Land ಕೊಟ್ಟನೇ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. Until 2013, we have not paid at all. I am appearing on a daily basis on this basis. Until 2013, we were not paying. Subsequent to 2015, and now we are paying for the tower based area also.
How much are you paying now?
For the tower based area, we are paying as on the date of drawing line.
What basis are you paying?
There is a direction, DC order. Now, from 2016, the DC will make an order. On the basis of DC order, we are paying.
On what basis does he make the order? Does he go by the guidance value?
Guidance value. He takes into consideration the markup, the guidance value of the lands, and then he fixes an amount per gunta. He fixes an amount. On the basis of that amount, we are giving 30%. Following the judgments, following the
30%.
judgments of this honorable court. Yes, ma'am.
You use the land completely and yet you're going to pay only 30%?
30% for corridor, and now, my lord, now after 2016, 85% of the land guidance value is being paid towards tower. Tower A, tower B, type of towers are there. For each tower, 85% of the guidance value is being fixed, my lord.
And for the corridor?
Corridor, again, we are paying for that also, my lord.
85%.
30% of the guidance value. Yes, ma'am. For the
ಇಲ್ಲ
usage
ನೀವು ಆ
of
ಟವರ್ ಜಾಗ 100% ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತೀರಾ? ಅದ್ರಲ್ಲಿ 85% ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ ಅಲ್ಲ, ಫಸ್ಟ್ ಟವರ್ ಗೆ ಅಂತ 85%
ಇಲ್ಲ,
ಕೊಟ್ಬಿಡ್ತೀವಿ.
when you're occupying the entire tower area,
Yes,
why can't you pay 100% compensation for the tower area?
it is as per the directions of the Union Ministry of Power. There is a notification
Today?
also.
ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಗೊತ್ತು ನಿಮ್ಮ ಸೇಲ್ ಡೀಡ್ ಹೇಳಿದ್ರೆ ಎಷ್ಟು ಅಂತ? 3 ಎಕರೆಗೆ. ಹಂಗಂದ್ರೆ ಅಷ್ಟೇ ಬರೋದು ನಿಮ್ಗೆ 1 ಎಕರೆಗೆ 15,000. ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ.
My lord, as on that date, point number 1, they were not the owners at all. And now,
They have a sale deed, isn't it?
in the year 2000, my lord, and they have come forward claiming for compensation only in the year 2008, my lord. Earlier, my lord, during 1980s, no compensation at all was being given. In fact, the farmers would come and request us to draw lines in their lands. They are not taking possession of the land, my lord. They will still continue to be the
No,
owners.
this talks about 10% for the corridor. You said 30%.
30%, now it is fixed, my lord. We are paying 30% of the guidance value. We are accepting the Telecast judgment and paying 30% towards the corridor area, usage of land.
Pay the same compensation, that's all. Guidance value of 2007.
2007, no, my lord, 1997.
Pay the same thing.
That time, there were no rules to pay.
No, there'll
Only,
be
my lord,
a judicial order now.
My lord, only concern is if we pay in this case, then
If you voluntarily pay, then I will not pass an order. You will not pay voluntarily. So I have to pass an order. Isn't it? If you have to
my
pay
lord,
something,
then during that relevant point of time, no compensation.
then I
was
will have to
being-
hold, even at that point of time, the law was the same. Whatever is being followed now, we'll have to apply retrospectively. It's a question of taking away a person's possession.
We have not taken possession of the land, my lord.
You have taken away his right to use the 1 acre of land for 25 years. What else is it?
It is like opening the.
ಅದಕ್ಕೆ ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು, if you are going to compensate him voluntarily,
Okay, my lord, we will just hold a discussion.
same
And
principle.
whatever best possible can be done. I will discuss.
Apply
with
the
the
same
officer.
principle, 85% market value, 30% as on 97, and pay, he will keep quiet. Or else I'll pass an order in the same lines. That this is the best yardstick, isn't it? You yourself have determined 85% and 30%.
That one was only after 2016, my lord.
I'll apply it retrospectively. If you have followed that guideline, why should I not accept it? I was thinking at 100% and 50%.
Subsequent to 2016 only, after that notification only, we are.
Or really, Illandra, I will 85%, 30%. Guidance value as on 1997.
I will just have a discussion and then.
Similar argument was advanced. This court has considered the very same, all the arguments of my friend. Pass the judgment. Karnataka case. Other
Correct.
argument is required.
Based on that only 30% is being given. We have accepted that judgment, but all those prospectively, my lord, not prospectively. This judgment is upheld in writ appeal also, my lord, and we have accepted this judgment. But
Then
prospectively,
I'm also inclined to think I'll apply the 2013 Act and say that since no award was passed prior to 2013, you will have to pay component of 2013 Act. Solation is 3 times.
Solation will not come at all, my lord, because we are not
For the
taking
land-
possession.
For the land you will have, for the tower footing, you will, for that if you pay 300%,
My lord, Land Acquisition Act is not applicable at all.
I'll make
my
it
lord.
applicable.
Solatium all will
if
not
you
come.
take somebody's land,
If some compensation is to be paid, I will definitely speak to the officers since they are aware of the court's mood. They will.
85% guidance value for the tower footing, 35% for the corridor area,
30%.
guidance value of 97.
All right, my lord, I will. Because
Monday,
Monday,
pursuant to the audit dated so and so,
I will make my submission.
the executive engineer is present. He seeks further time for securing instructions, relist on.
The last occasion, my lord, your lordships will take question that is the application is barred by limitation. My lord. On that ground, the revision has been dismissed. Reference code.
4/2/1988, an application was made by me to refer the matter to the court. At that time, that one person was claiming the right of the, therefore that both the petitions were referred on 4/2/1988. One matter was referred to the principal senior civil court, rural. That for enhancement, what they made is they have referred to the city civil. But the petition filed under the referred under section 3031 was allowed, and it is for held that I am entitled to receive the compensation according to the compensation. Thereafter, the wrong motion that they filed a petition to for enhancement of the compensation. As it was not maintainable, therefore an application was filed to refer the matter to the court, because after the order passed by the court and the holding that I am entitled for compensation, I am the owner of the property. Then thereafter that we have noticed that on 4/2/1988 itself, that the matter was referred to the civil court, that we have made that representation. That earlier round that the matter was, the petition was dismissed, and against which I have prepared a revision petition before the honorable. The matter was remanded, that after remanding, Lord, that instead of considering my claim on the square feet basis, because that my land is converted land much prior to the acquisition. So therefore, they treat it as an agriculture. That therefore, that they preferred an appeal before the honorable. This court has held that the opportunity is to be given and you go once again and lead evidence. That I have led evidence. After leading the evidence with the reference court has passed an order that I am my reference itself is in order by time. And I have not challenged the order passed under section 3031 appeal. That I did not challenge that order 3031 because it is held that I am owner and I am entitled for the compensation.
Your reference is not dismissed.
Reference is now dismissed on the ground that this part of time that this honorable court earlier has entertained and it's remanded.
What was the acquisition for?
The acquisition for the construction of the house.
Houses.
House.
What is the total extent of land acquired?
The total extent of the land is 14 acres. 14 guntas.
ಅಲ್ಲ ನೋಡಿ ಇಡೀ ನೋಟಿಫಿಕೇಶನ್ ಬರೀ 14 ಗುಂಟೆ ಅಷ್ಟೇನಾ?
ಅಲ್ಲ, total acquisition is larger.
ಅದಕ್ಕೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಂಪನ್ಸೇಷನ್?
ಅದಕ್ಕೆ ಅವರು that based on the agreement ಮೇಲೆ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ. That my contention is that.
ಅಲ್ಲ ಎಷ್ಟು ಬಂದಿದೆ ಎಕರೆಗೆ ಎಷ್ಟು ಅಂತ ಬಂದಿದೆ?
Earlier, the award was passed on 40,000 rupees per acre.
On the basis of agricultural land.
Reference that at the time of enhancing, that the reference court made me that I am entitled for 1 lakh per acre.
In your reference?
In my reference, that has been challenged because my land is already converted much prior to the acquisition. Just based on the square feet area that you have to apply and pay.
That the, after remand that the trial court has not considered any of the.
What is the evidence that was led in to show the value of the land? In the
They are not,
reference?
except the sale deed, they have not produced any material before the court. Simply they say that it is attached to the national highway. Except the sale deed, they have not produced any material.
Any material to show?
That the other document that the mortgage deed and other deeds are with you.
No, any independent document, if it is there? ಅಯ್ಯೋ ಅಷ್ಟೊಂದು ಎಕರೆ ಅಕ್ವೈರ್ ಐತಲ್ಲ ಅಲ್ಲಿ ಯಾವ್ದು ಕನ್ವರ್ಟೆಡ್ ಲ್ಯಾಂಡ್ ಇರ್ಲಿಲ್ವಾ?
That I have not. I will go to the.
If there is some award in the same land, I'll apply the same thing and grant you compensation.
I will take very. I will. Okay.
There is no appearance on the petitioner. Since the matter was of the year 2016, I find no grounds to adjourn the matter. Revision is therefore dismissed on non-prosecution. Last time ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಾನೆ ನಿಮಗೆ. I'd given you time. What is the matter about? ನೀವು ಬಂದಿರಲ್ಲ ಮಾಡಿ. Finally, next time you don't come, I'll dismiss it. The list.
Applications we've been appealing. Last week of hearing, my lords had passed me model. Say. Place in the concept last week. He's set up in another group.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನ್ ಹೇಳಿ?
Is regarding adverse possession ಮೇಲೆ case ಹಾಕಿದೆ. Ingredients of adverse possession have not been met. For the last 4 hearings, my lords, we have appeared, but the counsel for the respondent has not appeared. That is for the plaintiff.
2000 relist.
For giving another opportunity, can my lords have it next Monday? Requested for.
You could have argued it today.
Because he's actually held up in another court. He said, pass it over
Relist.
to 4:30, therefore I'm not asking for a pass.
Relist. BDA garu. BDA.
Petitioner. Or affair again.
Jayakumar Patil is appearing for the BDA.
BDA. ನೀವ್ ಯಾರಿಗೆ?
Petitioner is verified something.
Hmm.
So he is allotted sites to the petitioner. The fact that, 17 he drafts of petition. But point that we are service of senior consent.
Last time somebody from Bombay had come this case, isn't it? If you want to argue today, or else I'll pass orders. ಏನಾಯ್ತು ಕೃಷ್ಣ?
ಇದು commissioner ಸಿಕ್ಕಿಲ್ಲ. Like commission last time you have suggested some solution matter. Commissioner ಸಿಕ್ಕಿಲ್ಲ, ರಜೆ ಇತ್ತಲ್ಲ ನಮ್ಮ ಎಲೆಕ್ಷನ್ ಇದು ಅಂತ ಹೇಳಿ commission ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ. 2-3 ದಿವಸ. 2-3 days.
124
120.
allotment price I said do something ಅಂತಲ್ವಾ?
ಹೌದು, ಅಲಾಟ್ 124ಗೆ ಅಲಾಟ್ಮೆಂಟ್ ರೇಟ್ ಅಲ್ಲಿ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗ್ತದ ಅಂತ ಒಂದು ಕೇಳಿಕ್ಕೆ ಹೇಳಿದ್ರು.
ಇಲ್ಲ, ಜಗಮಾನ್ ಪಾಟೀಲ್ 124 ಅಲಾಟ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಸೈಟ್ ವ್ಯಾಲ್ಯೂ
ಸೈಕಲ್ ವ್ಯಾಲ್ಯೂ ಪ್ರೆಸೆಂಟ್ ರೇಟ್ ಅಂತ ಹೇಳಿ ನಾವು ಅದನ್ನು ಸ್ವಲ್ಪ ಹೇಳಿಕೊಂಡು ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ರು. ಬಟ್ ಕಮಿಷನ್ ಮೊನ್ನೆ ಕಂಟಿನ್ಯೂಸ್ ರಜೆ ಸಿಕ್ಕಿದ್ವಿ. 2-3 ದಿವಸ.
Thursday.
Last statement also. And 259.
My lords, this is a matter where we have reflected the name of the, no, last time I was told to produce the original records.
Before that, let us produce the document.
ಹೇಳಿ.
Measures, total extent not is about 16 acres. 16 acres and 15 gutas. Office not 17 gutas of Arab land. Therefore, the balance not 15 acres and 38 gutas. From the land not 8 acres of land was purchased by my petitioners, that grandfather. I registered date on 23/1965. But I produced the xerox copy and type copy, but we also wanted to use the original, but I have seen because
No, we don't have it. We don't have it. No, actually it is handwritten. What we have to apply.
ಏನು?
not there are two survey numbers, it is, it's a 20,
One is in respect of survey number 157, 4 acre. And in the second one, survey number 159, 8 acre. 8 acre. The second acre.
ಒಂದು ಉತ್ತರ ಭಾಗದ ಕುಷ್ಕಿ
ಸರ್ವೆ ನಂಬರ್ 159, 8 ಎಕರೆ.
ಫಸ್ಟ್ 157ನೇ ಸರ್ವೆ ನಂಬರ್.
157, next 159. 157 and 4 acres, that is not the subject matter of the petition. The subject matter is in respect of 159, extent of 8 acres.
159 ಉತ್ತರ ಭಾಗದ
ಉತ್ತರ ಭಾಗ.
ಚೆಕ್ಕು ಬಂದಿ.
8 acres. This is the same deed, Lord, dated 20th March 1965. Lord, thereafter, Lord.
I don't have a copy.
Thereafter, Lord, Ankaigoda, the person who purchased his land, died. Then, and his 4 sons, Lord, 5 sons divided the property in 1973.
ಈ ಸೇಲಿಡ್ ಯಾರು ತಗೊಂಡಿದ್ದು?
Ankaigoda.
ಅಂಕೇಗೌಡ ಸನ್ ಆಫ್
ದೇವರೇಗೌಡನ ಮಗ ದುರ್ಗೇಗೌಡ ಅವರು.
ಸೇಲಿ ಡೇಟ್ ಯಾವುದು?
20th March 1965.
ಅಂಕೇಗೌಡ ಅಲ್ವಾ?
ದುರ್ಗೇಗೌಡ. After his death, his 4 sons did not divide his property. 5 sons.
When did he die?
Died in year 1972. 72 he died.
Then
his 5 sons divided the property.
ಯಾರ್ಯಾರು?
Thereafter, he applied for Tata and this of this land after the division of the property.
Then registered ಏನು?
ಅದು not based on their Allotment.
ಯಾವಾಗ?
That is last week I take annexure G along with the reply statement.
ಯಾವಾಗ ಅಂತ ಹೇಳಿ ಸರ್.
ಉತ್ತರ ಪತ್ರಿಕೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. G along with the reply statement.
ನೆಕ್ಸ್ಟ್ ಜೀನ್.
Annexure G. Along with my reply statement dated 20th June 2012.
ಯಾವತ್ತು ಹಾಕಿದ್ರಿ?
20th June 2013.
ಯಾವ್ದ್ರ ಜೊತೆ ಹಾಕಿದ್ರಿ? ಯಾವ್ದ್ರ ಜೊತೆ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Reply statement.
Reply to the objections.
They filed the statement of objection, then I filed the reply statement. Along with the reply statement.
Reply. MR ಆಯ್ತಾ ಏನಾರು? MR ಆಯ್ತಾ?
ಆಗಿದೆ.
ಯಾವಾಗ?
That is on 21/5/1973. 21/5/1973.
MR number?
MR number 9 of 1972.
ಯಾರಿಗೆ ಬಂತು 8 ಎಕರೆ ಇದರಲ್ಲಿ?
8 ಎಕರೆ ಡಿವೈಡ್ ಆಗಿದೆ. 5% ಕಾಸ್ಟ್.
ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಾಯ್ತು?
Ankaigoda, son of, sorry, Ningegoda, son of
Ankegoda, got 1 acre 24 guಂಟas. ಆಮೇಲೆ ಅಂಕೇಗೌಡ ಅಲಿಯಾಸ್ ಪುಟ್ಟಪ್ಪ got 1 acre 24 guಂಟas. Then Marigoda son of Ankegoda got 1 acre 24 guಂಟas. Then
Yes.
Ramappa in Ankegoda got 1 acre 24 guంటas. Likewise, my lord, Yavaregoda in Ankegoda got 1 acre 24 guంటas. All the 5 got it. Thereafter, my lord, all the RTC up to date, my lord, up to the date of 2030. And because you also kindly take annexed A.
Yes.
Like
Notification 2006 ಅಲ್ವಾ?
notification.
So 2005 ಯಾರ ಹೆಸರಿತ್ತು? ಈ RTC ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಾ? ಎಲ್ಲಿ ಮಾಡಿದ್ರಾ?
Annexed A.
Next year is 2001, 2002.
From then, RTC in the proceeding.
My lord, it's 159 knee. It mentioned 159 knee. Code ಆಗಿದೆ.
159/2
Knee.
2 ನೀನಾ?
2 knee.
That is because we are not kindly see. Mutation interest not kindly see. All this land 1 acre 24 guಂಟas 1 acre.
Is the MR? Mutation extract ಎಲ್ಲಿದೆ?
ಅದರಲ್ಲಿ RTC ನಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ ಸಪರೇಟ್ ಆಗಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಇದೆಯಾ? MR
73 ಎಲ್ಲ ಆಯ್ತು. Thereafter we got further divisions ಎಲ್ಲ ಆಗಿದೆ. Further divisions ಆಗಿ ಅದನ್ನ mutation numbers ಎಲ್ಲಾನು annexed A ನಲ್ಲಿ ಇದೆ. Annexed A ನಲ್ಲಿ last one got it at column 10.
What was the notified survey number?
159 my lord. Survey number 159.
ಇಲ್ಲ I asked ಅವ್ರ ಮೇಲೆ ಬೇಜಾರ್ ಮಾಡ್ಕೋಬೇಡಿ, ನಾನ್ ಕೇಳಿದೆ ಅವ್ರು.
I'm sorry. Every time she is to interfere, that's the reason. Flow of thought ಹೋಗುತ್ತೆ. Lord, may I request Rashmi kindly take me, Lord, ink page 27. Serial number 175. Serial number 175. Survey number 159. They are not shown any sub numbers. Here the last to guide you.
Yes.
The total extent 16 acre 15 guంటas minus 17 guంటas karar. Here, Ashmi Gaitis have total 15 acre 8 guంటas. Here, Ashmi kindly see the names. Very, very important. Utilization. Annaya bin Nigeta, Shivanna, Krishnappa, Utilization, Ramegoda, and Nigeta. All these persons are the tenants in respect of the other 7 acres and 30 acres. Not in respect of 8 acres. There is one thing, one permission I would like to make. Here there is one name, this is the name that my learned friend wants to depend upon. Annaya bin Ningegoda.
Notified Katheder tenants
All these are tenants.
of 7 acres.
7 acres 38 guంటas.
Yes.
Not one submission is left to make. Here there is a name called Annaya bin Ningegoda. All these persons belong to some community belong. The name of Annaya bin Ningegoda also finds the place, the name of the owner who divided the property. In fact, I have clearly stated that
Then last look and you see. There is nothing. In fact, if really they are applied that line, preliminary notification, there is no change in the preliminary notification or in final. Even till today, we are continuing in possession and calculating the plan.
Yes.
Well, certainly in the year 2013, not the respondents will not try to enter upon the land. I have to do the except with the help of a
Next,
XLT photograph. JCB. Pull down the trees and wanted to occupy, take possession. Immediately acquisition comes and filed a petition on 1/4/2013. And by an order dated 9/4/2013, we have come before blood issued notice and granted interim order. There. My response submission is the land in respect of 7 acres 38 hectares as the subject matter of the land tribunal, and I have produced the order of the land tribunal for object.
ಏನಾಯ್ತು ಯಾರು ಕೊಟ್ಟಿದಾರೆ ಅದು?
ಅದು that litigation pending even till today, that is before the sum for that some petition. In that may not the tenants claim that the land has been acquired, compensation for respect of 7 acres 38 hectares. Same document has been filed by Manad Friend in this case also, in respect of 7 acres 38 hectares. And that matter is not, several litigations are there, and the matter is pending before the Supreme Court.
They have not challenged the acquisition.
They have not done that. When I came to know about this fact, regarding the acquisition, which only year 2013, then only I have done. Now, not my full submission, that not without notice or without acquiring the land in accordance with law, and what I want to do. Not that try to, therefore, I am for the law. So content, but without notice, not as a law. Not like when once the land is sought to be acquired, a notice is a primary requirement in respect of the owner of the land. Only there are additional notice, then you not land procedure. Here is the case where without notifying them, or without hearing them, or without giving notice, this acquisition is sought to be made. Now, I have several other documents also to the last. So that and last occasion, this statement on the other side to produce the records to show whether the notice has been issued. My land shows any document that even a single notice that will issue the petition and what happened after the interim order was passed, then the Lord KIDP got it.
JD?
2010, after the interim order was passed and the notice was served on them. They were enlightened about this. Then my Lord, in the civil court, they made an application to bring these petitioners on record before the civil court. In the reference proceedings. It is only then my Lord, that is after the petition was filed, then this subsequent development has taken place, and those proceedings are pending even today. Pretending that this is
What was the acquisition for?
Lord, this is for industrial purpose.
My lords, annexure R1 of my document, my lords, statement of objection, which was filed on 26/2013, my lords.
Yes.
That is, my lords, at page 8.
Yes.
The entire extent is mentioned 16 acres, 15 guntas, my lords, 159 survey number. This is of the year 25/11/2005. At the bottom, the 2005 and 6 is mentioned. Then, my lords, the names are Shivalinga Gowda, Annaya, Shivarna.
So are you saying that 159/P in 1 is not acquired?
159 to me, what my learned
Not
friend,
acquired?
my lords, what had happened, we have filed LAC. And in that LAC, we have put the names of all the people whose.
If you are arguing that the notified katas were served,
Please, my
I will
lord.
record a statement 159/2 ni was not acquired,
We
was
have-
not notified.
My lord, we have acquired 159 survey number measuring 6 acres 15
They
guntas.
have a registered sale deed. Revenue authorities have mutated their name. They're showing it as 159/2 N or E, whatever.
Yes,
It is not their responsibility to ensure that whether the survey number is coded correctly or imported correctly.
yes, sir.
Their name is there. You hear them and pass orders.
My lord, that is what we have done, my lord. We have filed the LAC. In LAC, we have given.
Not in LAC. Before you pass an order 28/3.
We were not aware, my lord. All we had was this page number 8.
Right, now that you're aware, I'll quash the declaration. You hear them and pass orders.
Already the acquisition is complete. Possession is handed over. All entire extent, 16 acres, 15 guntas. This is an extent of 544 acres, which were acquired in 2006. Entire extent has been handed over to the beneficiaries, and my lords, I have got all the lease deeds. Third party rights have been created, my lords. LAC proceedings are pending before the referral court. They
To whom have you allotted this 8 acres?
Please, my lord.
To whom have you allotted this 8 acres?
My lords, we have provided the list of all the
This 8 acres, whom have you allotted? When was the award passed?
award was passed in 2013, my lords.
2013.
13.
You have the date?
My lords, the date is on, award date is. My lords, 26/8/2013. The LAC
That
proceeding.
is after the writ petition.
Yes, my lords. The award was passed for entire extent. For entire 500.
When did you take possession?
Possession we have taken immediately, my lords. The
When?
date on which we have taken possession is. My lords, on 13/1/2007.
How much?
13/1/2007.
13?
1 January 2007.
Even before you pass the award.
Please, my lords. Award was passed in 2013.
7 months before the award, you take possession?
My lords, physical possession we have taken on 19/1/2007.
2007.
Please, my lords.
The award is passed in 13.
13. There was
You
a-
take possession before the award is passed?
Lord, may kindly produce annexure R3, page 7. Along with the objections which are filed on 28/3/2023.
Page
Page 7, my lords.
2.
Page 7 of the additional documents, my lords, which are filed. Additional objections on 24/3/2023.
Page 7.
Page 7.
Yes. But how can you take possession even before the award is passed?
That I just seek instructions on that.
Alright, to whom have you allotted this 8 acres?
My lord, total 16 acres in the survey number. I have given the list of allottees along with my objections.
This exact extent of 8 acres, whom have you allotted?
My lord, exact we will not be able to.
Why not?
I'll figure out, my lord. I'll find out who is the 8 acres whom it has been given, my lord.
Tell that to me if
My lord, I have the list of entire 16 acres, 15 guntas. I don't have specifically for this 8 acres.
either way you've not heard them and you have passed an award 8 years after the declaration.
Award was passed. in it.
Then what is the justification?
Because the extent was quite huge, 455 acres of land.
There was no impediment for you to pass the award.
I will verify why the delay there was with respect to the passing.
This court has held a delay of 9 years is fatal.
I'll verify the reasoning as to why there was a delay in passing the award, my lords. I'll verify that as well. Because that was not the issue here, my lords. His only contention is that his name was not reflecting, my lords. For that, I have given my justification in annexure R1 that.
That is no justification. You're taking away somebody's land. If his name was not there in the revenue records, I would not have allowed him to argue. His name is there in the
In
revenue
one of
records.
the RTCs, my lord. One of the RTCs it is there, but the difficulty, my lord, there is in 159 2 knee. So that was
You
part.
should ask them. They are the ones who did that.
I'll verify that. Why that?
Or their caution notification, hear them and pass orders.
My lords, I'll seek instructions so far as that.
Or give them that developed land, 40%. Maybe they'll agree. Toltira? Maybe then they'll agree.
It was 2013, my lords already.
What can you, if you not notified them? They have not taken compensation.
My lords, compensation has been deposited.
They have not taken.
They have not.
Then-
Amount has been deposited in the civil.
That you can take it back. Tomorrow.
My lords, not tomorrow, my lords, may kindly have it on the Monday, my lords. I'll seek
Monday.
instructions for.
Tuesday. See if you can give him 40% developed land, he'll probably. That's a better way of buying peace, isn't it?
2013, we have already given it.
If you lose the land now,
It will lead to multiple litigation, my lords.
that's why if you give it to him voluntarily, he will withdraw the petition. Or else I quash and then
I'll seek instructions.
230. Don't matter. Then, same. Yaru. Where is he?
Reason why respect to the adjacent property not very the interim order that has been acted. Very same tone.
Injunction davatare the prayer.
Page 103 the interim order not that very adjacent site.
Where is he? Who was there to take notice there?
This is the reason why I not show copies.
Shri Karthikeyan to take notice for respondents. Since it is stated that in respect of the adjoining property, this court in WP in 635 of 2024 has directed parties to maintain status quo, there shall also be an order in this writ petition directing both parties to maintain status quo as it exists today. Post along with WP 9635 of 2024. ಯಾವತ್ತಿಗಿದೆ ಅದು? ಒನ್ ಫೋರ್ ಗಿತ್ತಂತ ಯಾವತ್ತು 1-4 ಗಿದ್ದಿತ್ತು ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ಡೇಟ್ ಆಗಿ
Very interesting. Occupancy denied to be on the premise.
Date code.
May I please, your lords, item number 55 in list number 1, the matter pertains to a school, your lordships. Today it was listed for objections of respondents. Today it was listed for objections of respondents, so kindly have it up tomorrow, your lordships. The matter pertains to a school, item number 55.
Let
was
them file
listed.
objections. They should
You
file
ca-
objections, isn't it?
The respondents have to file, kindly have it up tomorrow, your lordships.
For what?
Your lordships, we need to argue the matter soon. The matter pertains to a school which has to be reopened.
He's
For the
given
academic
given
year.
a date, come on that date.
Results matter.
I represent the respond number 3 council. It may kindly be taken up on 22nd, subject to the of the honorable court.
I
In
think
12th?
Friday it could be taken up. It's covered by the judgment. The notification is quashed by this honorable court on the ground that no scheme is sanctioned. Where a cooperative
Covered up.
society.
There are several arguable points which the petitioner has raised. It's not covered. HMT does not apply to this case. I will demonstrate.
My lord,
Number second.
serial number 28, my lord. It has been listed on Thursday.
28 of.
The list number 1. Kindly have it on Friday, my lord. I have informed the petitioner council.
ಅದಕ್ಕೇನಾಗತ್ತಿಲ್ಲ.
Somebody had appealed, isn't it?
ನೋಡೋಣ ತಗೊಳ್ಳಿ.
Thursday.
List one
Friday,
serial number
Friday,
33 passed over, my lord. List one serial number 33.
ಯಾರು ಬರ್ಲಿಲ್ಲ, I called.
ಇಲ್ಲ, 2:30, I could not be here, my lords, it was passed over. Maybe taken up tomorrow, my lords. Serial number 33.
30?
33, my lords, list one.
ಅದೇನಕ್ಕೂ ಆಯ್ತಲ್ಲ. ಆಕ್ಷನ್ ತಾನೆ.
Auction.
ಯಾವತ್ತು? ಇದಪ್ಪ ಸ್ವಲ್ಪ. ಇಲ್ಲ ಅವ್ರು. ಎಸ್ ತಿಮ್ಮಯ್ಯ. ನೀವೇನು 10 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ. ಕೊಡಿಸ್ತೀನಿ ಅಲ್ಲ. He asked me, what is that from your end, you can propose an amount. I said, I will ask them, it can be 5 lakhs, 10 lakhs, whatever, if they are willing to give, I will ask them. ಅಂತ ನಾನು ಹೇಳಿದೆ ಅಷ್ಟೇ. I never committed that I will,
What are you willing to pay?
because that I need to ask him, because till now what we are asking was, if they are ready to pay the interest, we'll let it go.
ಅವ್ರು ಎಷ್ಟು ಕೊಡ್ತಾರ ಅಷ್ಟೇನಾ?
5 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂತ ಕೇಳಿದ್ರು. 7 lakhs ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಇದು above that ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಹೇಳ್ಬೇಕು ಅಂತ ಏನಿದೆ. 12 lakhs.
ನೀವ್ ಹೇಳಿದಂಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
12 lakhs. 7 lakhs more we agreed before just not
ಎಷ್ಟಾಗುತ್ತೆ? 12% ಅಂದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? 12% ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟಾಗುತ್ತೆ?
12%.
12%.
28 lakhs ಬರ್ತದೆ.
ಕೊಡ್ತೀರಾ?
ಆಗೋದಿಲ್ಲ ಸರ್.
ಮತ್ತೆ ಅವ್ರು ಎಷ್ಟು ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ತಾರೋ ಅಷ್ಟು ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. How much are you willing? Find out
I'll find out.
tomorrow.
Serial number 14. Serial number 17, serial number 42, it was a court or move matter. But the date is given to 23rd, I have sometime this week. 42 minutes. 41 ಅಲ್ಲೂ ಬಂದು 42 reach ಆಗಿದೆ. Court or move matter. 42, sometime this week, Friday, Thursday, any convenient day.
Next week ಬರ್ಲಿ.
Serial number 14, serial number 14, list number 2, the matter is very short, my lord. There is, in the next week, my lord, it may be taken up.
What's the date ಕೊಡ್ತಾರೆ?
Serial number 12, my lord.
Number 2, serial number 17, entry ಮಾಡ್ರಿ
ಮಾಡ್ತಾರೆ.
Serial number 12, my lord. 22, my lord. Serial number 12.
19th ಕೊಟ್ಟಿದ್ದೀರಾ?
Friday ಕೊಟ್ಟಿದ್ದೀರಾ?
We can take a chance on that day.
Difficulty, my lord, 22.
Friday ಬರ್ಲಿ ನೋಡ.
ಶುಕ್ರವಾರ ಒಳ್ಳೆದಿದೆ.
ಸರ್, ಇದು ಧಾರವಾಡ ಬೆಂಚ್ ಏನಾಯ್ತು ಸರ್? ಅದು 4 ಮ್ಯಾಟ್ರಿಕ್ ತರ Sir, court officer. Court officer.
Court officer, sir.
ಇದು ಧಾರವಾಡ ಬೆಂಚ್ ಒಂದು 4 ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ, ಅದು ಏನ್ 4 ಡಿಸ್ಪೋಸ್ ಆಯ್ತಾ? ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 482.
Court officer, sir.
Court officer. ಕೇಳ್ತಾ ಇಲ್ವಾ? ಅಲ್ಲ ಅದು
Court officer, sir.
ಹಲೋ ಹಲೋ ಮೇಡಮ್ ಕಳಿಸ್ಲಿಲ್ಲ ಯಾರನ್ನು?
ಹೇಳಿ ಸರ್.
ಸರ್ ಇದು ಬೆಂಗಳೂರು ಧಾರವಾಡದ ಏನಾಯ್ತು ಸರ್? ಅದು 4 ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ, ನಾನು ಈ HGP ಮಾತಾಡೋದು ಧಾರವಾಡದಿಂದ.
ಯಾವ್ದು ಫಾರೆಸ್ಟ್ ಇದ್ರದ ಫಾರೆಸ್ಟ್ ಆಕ್ಟ್ ಮೇಲಿಂದ?
ಫಾರೆಸ್ಟ್ ಅಲ್ಲ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 2, 2.1, 2.2.
ಆಯ್ತು ಸರ್.
ಅದು 3 ನಮ್ದು ನೇಮ್ ನೋಟ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಸರ್ ನೀವು.
ಪ್ರವೀಣ್ ವೈಡಿ.
ಪ್ರವೀಣ್ ವೈ ದೇವರೆಡ್ಡಿ ಅವರ ಸರ್.
ತೋರ್ಸಿದಿ.
ಪ್ರವೀಣ ವೈ ದೇವರೆಡ್ಡಿ ಅವರ ಅಂತ.
ಪ್ರವೀಣ್ ವೈಡಿ ಅಂತ ಐತಲ್ಲ, ಅದನ್ನ ತೋರ್ಸಿದೀವಿ ಹಂಗೆ.
ವೈಡಿ ಬೇಡ ಸರ್, ದೇವರೆಡ್ಡಿ ಅವರ ಅಂತ ಹಾಕೊಳ್ಳಿ ಸರ್, ಕನ್ಫ್ಯೂಸ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ ನೀವು ಇಲ್ಲಿ ಹಾಕಿದ್ವಿ ತೋರ್ಸಿದ್ವಿ, ಹಂಗೆ ತೋರ್ಸಿದೀವಿ ಫೈಲ್.
ಅಲ್ಲ ವೈಡಿ ಅಂತಂದ್ರೆ ಅದು ಗೊತ್ತಾಗಲ್ಲ, ಕನ್ಫ್ಯೂಸ್ ಆಗುತ್ತೆ. ವೈಡಿ ಅಲ್ಲ ಸರ್, ದೇವರೆಡ್ಡಿ ಅವರ ಸರ್. ಸ್ಪೆಲ್ಲಿಂಗ್ ಮಾಡುತ್ತೆ ನೋಡಿ, DEVAREDDI YAVARA.
ನಿಮ್ದು ಇದು ಡಿಸ್ಪ್ಲೇ ಐತಲ್ಲ ಇದ್ರ ಮೇಲೆ, ಅದನ್ನೇ ತೋರ್ಸಿದ್ವಿ, ಅದನ್ನೇ ತೋರ್ಸಿದೀವಿ.
ಅಲ್ಲ ಅದು ರಾಂಗ್ ಆಗಿ ಲಾಗಿನ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಅದು ನಾವು ರೀನೇಮ್ ಕೊಟ್ಟಿದ್ರು ಅದು ಹಾಗೆ ಬರ್ತಾ ಇದೆ, ಸ್ಪೇಸ್ ಬರ್ದೇ ಇರೋದಕ್ಕೆ. ಯಾಕಂದ್ರೆ ಆತರ ಮಾಡಿದ್ರೆ ಕ್ಲೈಮ್ ಆಗಲ್ಲ ನಮ್ದು. ಪ್ರವೀಣ್ ವೈ ಆದ್ರೆ ಕ್ಲೈಮ್ ಆಗಲ್ಲ. ಪ್ರವೀಣ ವೈ ದೇವರೆಡ್ಡಿ ಅವರ ಅಂತ ಹಾಕೊಳ್ಳಿ ಸರ್.
ಆಯ್ತು.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.